Begin. Would you take your seat, please? Good evening and welcome to the monthly meeting of the Board of Arlington Board of Zoning Appeals, also known as the BZA. I'm Judy Freshman, Chairman of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malis, Paul Melnick, and Peter Owen. Also present is the professional staff, including Sam Emba, who serves as Acting Secretary to the Board of Zoning Appeals, Arlova Vaughn, Zoning Administrator, Simon Keynes, Administrative Technician, Cliff Hogan, Assistant to the Zoning Administrator, and Louis Araya from Department of Environmental Services. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance. And we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modification will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the property surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith, and any hardship was not created by the applicant, that the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area, that the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, that the relief or remedy obtained through this variance is not available through a special exception process as provided for under the ordinance and/or subdivision ordinance. When deciding appeals of the zoning administrator, the Board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have determined the following time limits for speakers to be sufficient: 20 minutes for appellants and appeals, 5 minutes for applicants for use permits and variances. For use permits and variances, we have deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Case number V-11099-16-VA-3. Variance request by Elena Keith, owner, to permit a setback of 4.5 feet to the wall instead of 10 feet as required, and 2.9 feet to the eave instead of 6 feet as required from left side property line. To permit an aggregate side yard of 12.5 feet instead of 18 feet as required, and to permit a setback of 18.2 feet to the rear property line instead of 21 feet as required from a rear deck for a new 3-story single-family dwelling in RA 8-18 zoning district, premises known as 2116 North Culpeper Street. Staff recommended that the board adopt the attached resolution granting the subject variance permit with conditions.
Thank you. Questions for staff? Are you here to answer questions, or did you have a presentation? I'm here to answer questions. Okie dokie. Thank you. We hear from the applicant, please. Mr. Lawson.
Good evening. Thank you, Madam Chairman. For the record, I'm William B. Lawson, Jr. I represent the applicant. When this was last before you, it was when Ms. Keith was trying to preserve her nonconforming house that had lost its nonconforming status. You all denied that request, and after that we hired Mike Stevens, who's an architect who's been practicing many years in Arlington, and we asked him to come up with what would be a by right layout. He did, but he made one suggestion. He suggested that we utilize the existing foundation on the left, as you face the lot, on the left side of the lot. He said this would save us a lot of money if we were able to do that. We worked with Amanda before she left the county to come up with a design that staff could support, which we have done. The staff has a detailed staff report which summarizes the situation. The justification for the request we would respectfully submit is the fact that it's an undersized lot. The storm sewer easement in the rear of the lot kind of forces the improvements to go forward and go to the left, again, facing the lot, going to the left. Utilizing the existing foundation, as we stated, would save a lot of money for the applicant. And this encroachment already existed because we're using the foundation of the prior house. The neighboring property, which is to our left, is the parking lot for the condominium, so there's not a residence to protect on that side yard. Another thing that the neighbors had brought up was that the sidewalk situation was dangerous, and we do agree it should be corrected. And understand the county is going to be doing a study, and they aren't ready for a condition as I understand it, but I just want to state for the record that we'll cooperate with the county in coming up with a solution of what admittedly is a difficult situation. I have two things to hand out. The first thing is the pictures of the parking lot, which is to the left of our property, the side for which we're requesting the modification of the by right setback. And the second thing I'm going to hand out is a variance that I did, or a use permit I did in 2010 for Mrs. Young. And it's kind of a similar situation. I think only Mr. Smith was on the BZA when that case was before you. And, you know, this is kind of a unique neighborhood. We have a lot of lots that just simply don't comply with the ordinance. You know, they're wide, but they're narrow, they're small. And, so you have a lot of different types of lots. And on this one, what happened was the builder, for some reason, didn't measure from the property line. He measured from where he thought the property line was. And the BZA did, in fact, grant that use permit. And I think it just is indicative of the difficulty of some of these properties in this particular area. So Ms. Keith would like to spend just a minute or two sharing a couple thoughts with you, and I'll hand this out.
Thank you. Ms. Keith.
Good evening, Madam Chairman and the board members. Be here, and I'm going to be very short. It has been a journey building this house. I've learned so much about construction at this point. I've learned so much how important it is to cooperate, to find solutions. We did sit down with Amanda Clement, who was the coordinator for the board, for the Board of Zoning Appeals. And we did quite a bit of work with the county on different levels. I worked with Sam. I've met with Sam so many times. And Liliana, we worked together with her. We really did as much as we could to find the best place for the house. And it turns out, because of the lot is so small, this is the only place where the house could be. To make a smaller house just doesn't make sense. The footprint as small as we could possibly design. So that's where we are. And many members of the community came to me when I was coming with my engineers, with my attorney, with our architect. They've been asking what was going on, and all of them really expressed support. They said, we want this house to be built. We can't see this continuing for another year. Please do something. Build this house. Do something. We can't see this anymore like that. So they, basically, that's all the members of the community who were coming to me, they were saying, please finish it up. You can do it. So I just came here to express their message. And that's where I am. So thank you so much.
Thank you.
Thank you.
Mr. Lawson, are you finished?
Yes, ma'am.
Okay. We have speakers.
I'm sure.
Mr. Owen.
We received a lot of material from staff, and I just wonder if it's not clear to me how much the record or the participants in this hearing are aware of everything we got. And so I just wonder if you think it might be a good idea to have staff make clear what it is that the additional materials we have. And if so, it doesn't need to be right this second, but I just thought I would.
Is staff prepared to do that, to summarize some of the last minute? We received a lot of information that we haven't had time to even look at.
Staff received a revised disclosure statement
From the applicant.
from the applicant. Staff received a letter from Tracy Sean Grainer.
Maybe
Opposing the project, opposing the project. Staff received a letter from John M. Longston, Citizens Association of Halls Hill. They call for the project to be deferred until applicant have fully presented the case to the neighborhood concerned. This one is, again, from Tracy Granite, created by Tracy Granite.
She's one of the speakers.
Letters of non-support for this variance request. Those are some of the letters which I have.
And this?
We have a map from staff from DES,
I can explain that.
which he's here to talk about it. I think that's all I have.
Okay, thank you. Let's have our speakers, and then we can get back to individual issues. Sherry Young.
My name is Sherry Young, and I reside at 2014 North Culpeper Street. And I'm a realtor, and I originally sold this property. It was belonged to a family member. I sold it in 2004, and with Mr. John Melnick, who helped me with it. And there were impacts to the property at that time that we couldn't resolve. So I know that back in 2004, there were problems with it. So I've been a realtor in the neighborhood for almost 20 years, and I've watched properties appreciate. And I feel that if a person pays the amount of money they pay for some of these properties, and about 20 of those properties that I've sold have had impacts like this, where they have had to have maybe 1 to 3 different surveys because they couldn't correct all of the setback issues. So I feel that at this time, if a person spends this kind of money to buy a property and they have something that will conform to the neighborhood, I feel that they should be able to complete the building as a home, just like anybody else would want to build their home. And it's taken, I know, a considerable amount of money to fix all of these things, which I don't know if they'll ever be fixed. But I still feel that a person should be allowed to build their home.
Thank you.
Approved plans.
Thank you. Tracy Griner.
Good morning. My name is Tracy Griner, or good evening. My name is Tracy Griner. I'd like to once again point out that this slide does not represent the true property lines of the property. She does not own 1,100 square feet of the back piece of the property. I don't think I should be penalizing, because I brought this up at the last meeting for time, that this is not her whole property. I do not support the current variance request on the basis that zoning has even admitted she can build a house by right. On my documentation on page 2, on her documents to zoning of the survey, she even has the outline of a home built to the setbacks of the county that I have highlighted in blue. Her survey is on page 16 of the staff report, highlighting what she wants to do in yellow. Now, she was originally granted a variance that alleviated the hardships to add on, remodel, build up. She put every hardship back on that property when she tore the house down and voided that first variance request. She has now come back and wants to build a 3-story house totaling 3,900 square feet, not including the basement, when the original house would have been 1,800 square feet, not including the basement. If she built by right, she is still building a 3,300 3-story square foot home with an addition to a basement. The footprints, 37 by 36, 32 by 35. Not much of a difference between the two. It seems like zoning wants to either sweep it under the rug, get her out of their hair, just whatever, but I can't believe when we are being told by zoning after they shut her down that she could not build on any part of this original foundation.
Thank you. I have a speaker slip for the Civic Association without a name. Is that you?
Yes, I was the one thrown under the bus. I am speaking on behalf of Alexandra Boshin, the president of the John M. Langston Civic Association. Miss Alana Keith is seeking a variance to build a new structure at 2116 North Culpeper Street. The proposed structure is to be substantially larger than the project she presented to the Civic Association at a full body meeting in February of 2016. Since her initial and only presentation, the property has generated significant concern within our community, ranging from expositions of general worries to vocal complaints on construction noise, debris, and general nuisance. This is now a monthly topic at our Civic Association meetings. Recently, Ms. Keith inquired about presenting her latest variance request to the June full body meeting. Since the inquiry was made within days of the meeting, we were unable to accommodate her presentation request due to the short notice, insufficient information provided by her, and association procedures and administration of the full body issues. Unfortunately, this has been a pattern of interactions with this property owner over the last few years. Lastly, several residents have expressed concerns on the seemingly hyper speed at which this variance has made its way to the board for review. Apart from the appearance of an irregular and abbreviated timetable in the county zoning process, particularly when compared to many other applicants in the community, Mrs. Keith, it would seem, has circumvented our community's goodwill, due process, notice, and opportunity to be heard. Accordingly, I ask that the current variance hearing be deferred until after a time in which Ms. Keith has presented her new proposal to the community, our next full body meeting. Because of the significant and ongoing neighborhood concerns, it is imperative that I properly advertise this agenda item to our community members to ensure that all stakeholders are able to attend so that their concerns, support, and voices may be heard. Warm regards, Alexander Boshin. Because of a summer recess, our next full body meeting will not be until September 29th, 2017.
Okay, thank you.
Thank you.
Jim Derrick, to be followed by Stephanie Derrick.
Good evening, ladies and gentlemen. Thank you for your time and attention. My name is Jim Derrick, and I live with my wife at 2022 North Culpeper, within sight of 2116 North Culpeper. We have been witness to most of the events that have occurred with this property. Thank you for the opportunity to speak and for the denial of the applicant's request for a variance in March. This is an aberrant situation for our community, and I'd like to point out some issues I hope the board will consider in making its decision. My wife and I have included supporting documentation in the handouts provided. You will again see letters of non-support and expressions of distrust with the owner. She has made little effort to engage, provide clear plans, and respond to community concerns. We were contacted by Mr. Lawson and suggested to him in early June he needed to work within the community. Their attempt to contact their civic association at the last minute allowed them to check the box, but not actually have to engage with neighbors. There is confusion in the numerous documents filed. For example, on 3 documents, I attached them, it states 2, 2.5, and 3-story house. Which one is it? The plats provided are overwritten with many notations so that boundaries are hard to interpret, and the existence of the front basement in the easement is questionable. Does it stay or does it get dug up? Safety issues with the sidewalk have been brought up. I also like to point out you will probably not come across a situation like this, nor will it have to be on the board for any amount of time. The brazen and intentional actions of this owner defy any reasonable standard. Please consider this and look at the photos showing the owner herself directing workers in unlawful actions such as excavating soil onto her neighbor's property, which is that piece in the back, which that doesn't represent, but it's there, and she does not own it. Digging the basement in violation of her variance, instructing the demolition of her house in January. We have many more pictures, and the numerous county citations and legal proceedings are evidence of just a fraction to the extent. Think about this. If you wrap your house in black plastic so no one can see it, and then dig a basement by hand and wheelbarrow, which was done, it's not accidental.
Thank you.
Appreciate your time. Thank you.
Stephanie Derrick, to be followed by Bill Baswell.
Good evening. My name is Stephanie Derrick. I live at 202 Culpeper Street, just down the street as well. I think that there's also some procedural issues which have been violated with this application, which call for at least a deferment. The applicant's disclosure statement is deficient. According to Virginia law, every applicant has to submit a complete and accurate disclosure statement. She has not indicated on her disclosure statement that she has a mortgage holder for the property, namely the August 2nd, 2016 note and deed of trust granted to Rosen Financial LLP, making her application deficient. It was also not submitted timely to be heard at the July hearing date. As you know, the county deferred the hearing on this application in June because the staff received supplemental information from the applicant that needed to be advertised after the public notice was published. Per the BZA's own guidelines, copied below, applications completed after the filing date cannot be processed until the next hearing date. Therefore, she did not make this deadline, and all the information you received was well after May 10th, including nearly all the signatures from non-neighboring residents in support of this application and the so-titled expert report. So if fairness is the issue, then is it fair to all the people sitting in this room right now, or the people in our community who have followed the rules, that she has granted these exceptions over and over again? In addition to these issues, the owner has demonstrated a flagrant disregard for laws and procedures, and we ask that you deny this variance request and no variances in regards to this property. If she chooses to, has put this hardship on herself, and if she has decided that she wants to build on this lot, then she needs to follow all the rules and have no variances. Thank you.
Thank you.
Oh, and never mind.
Bill Braswell.
I'm Bill Braswell. I live in the Charlie Heights Civic Association, which is just to the west of this civic association, which this property is. For many years, I have been actively involved in all sorts of efforts to revitalize Lee Highway. We are finally getting to where we're ready to take off. One of the jewels along Lee Highway is the Heidelberg Bakery. I have been a customer of the Heidelberg Bakery since it was down in the Lee Heights Shopping Center. I think you all know, if you go to the Central Library, we have pictures of people along the walls. One of the owners, Carla, is in one of those pictures. And this development has been going on a long, long time. Yes, no, maybe, deny, and whatever. If you decide to approve this tonight, can we put a condition that this is the last chance? And second, when you think about this, we think about the Heidelberg Bakery. We think about the Langston Brown Community Center across the street. How will these efforts be a plus to Lee Highway and to the community as a whole? These are the big questions. I don't know if y'all can answer those or that is within your purview, but I hope that y'all can make a decision tonight that will not just be of benefit to this little area, but the larger area around it and all of Lee Highway.
Madam Chair?
Thank you. Yes. Mr. Braswell.
Mr. Braswell, nice to have you here with us. Nice to have you here with us tonight. Are you aware that the Heidelberg Bakery, we have documentation that the Heidelberg Bakery opposes this variance?
Yes, ma'am. I have talked to Carla and Wolfgang on a number of occasions. Yes,
So your comment is?
I am coming as an individual. I am not speaking for Carla or Wolfgang. I am trying to represent my interest of something I've been working on forever, Lee Highway, trying to make this a jewel. Ms. Malice, we have a 20% vacancy rate in our office buildings. We're not going to get that down. Small businesses are going to be the backbone of our businesses in this county, and I don't want to damage them in the slightest. I'm thinking holistically, not.
Thank you. I have one more speaker slip, which I cannot read. Apparently somebody put something that looks sort of like John. So if you put it in a speaker slip and you can't read it, going once. Okay, we're finished. Thank you. That's the last speaker. Mr. Lawson.
Yes, ma'am. Very, very briefly, I wanted to respond to some of the testimony. The contractor took down the wall that caused the loss of the nonconforming status. Ms. Keith did not do that. She didn't want it done. It's caused her all kinds of anguish. We were ready to go last month. We were ready to go to the Civic Association. At the last minute, the Civic Association called Ms. Keith and told her not to come. The site has been cleaned up. That's before it was cleaned up. We worked with Shariar and cleaned it up under his direction, and she was actually cited to go to court. And before that, we worked with him, and we got it we got it cleaned up to the point where they dismissed it. And the last thing I wanted to share is that the Heidelberg Bakery received a variance, and I think it's a little bit unfair of a commercial business that received a variance to turn around and say to a residential neighbor, even though we got our variance, you can't have yours. Thank you.
Thank you. Questions, comments? Mr. Smith.
Madam Chair, one quick question. We did get a new disclosure statement, and I presume, Mr. Lawson, that you got all the things that the acting secretary just described? I know that you got the disclosure statement because you presented that to us.
Mr. Smith, I did not file the disclosure statement. My understanding has always been that it calls for equitable ownership, which does not include lenders.
Have you seen it?
I have not, sir.
Piece of paper?
Have you? I think Ms. Keith filed that.
Okay,
Yes.
my question goes to, are you the manager of the Heidelberg AG LLC?
Yes,
Okay.
yes.
And that entity
That is
lent the money to you, the
exactly.
owner of
Yes, exactly.
Right.
And that's being disclosed in the statement.
And just the second question is that this name Heidelberg AG LLC is not connected with the bakery at all.
Absolutely
It's a name
not.
that you just chose
Because of the bakery, actually.
proximity to
Because of
the-
proximity. And I've been to Heidelberg in Germany, and it's a gorgeous city. So that's why I call this house Heidelberg.
Ms. Keith?
Thank you.
You're welcome.
Ms. Keith?
Mr. Owen.
Ms. Keith? The way that this form works, the address of the entities listed are supposed to be listed in the box. And there's no address listed for either Heidelberg AG LLC or for yourself, although you signed at the bottom with an address on Colesville Road in Silver Spring.
That's right.
So you live in Silver Spring?
That's right.
And what is the mailing address for Heidelberg AG LLC?
The mail is being also sent to the same address for the company
Which address?
in Silver Spring.
In Silver Spring. So the Colesville Road address that you signed with is the address of both the company
That's
and yourself?
correct. Yeah.
Thank you.
You're welcome.
Other questions? Questions for staff? Questions for applicant?
I have questions for staff, but whenever.
Ms. Malice?
Just, yeah, you're good. In the testimony, there was some mention of the fact that in some places it says 2 stories, in some places it says 2.5, and in others it says 3 stories. Can you clarify why that might be different in different places? For instance, in the description on the first page, it says a 3-story single-family dwelling. And then in the application, it says 2-story, and I think on the plat, it says 2.5 stories. So,
It is actually a 3-story single-family dwelling.
so the application is for a 2-story building, but this is actually a 3-story building?
No.
Mr. Lawson?
This survey has been done by the firm that does, it's a geoenvironmental engineers, and they've done it according to what they've seen on the site. So whatever exists right now, they count as a story. The other part that doesn't exist yet, it's going to be new addition. They count as 3-story, and that's how they created the plat. That's why you would see difference. Some particular part of the structure marked as 2-story above existing, and some part of the structure would be 3 new story. That's where the difference.
Existing, did you say?
Yes, yes.
Total of 4 stories?
No, it would be
2 above existing.
just 2.
Above existing.
Folks, a basement is not a story. And so it's 2 stories, and they've utilized some of the attic space. But a basement is not a story, so this should be considered a 2-story house. Some might consider it a 2.5-story house.
Staff, I would like your opinion on how many stories this building is.
Based on the definition of what a story is in the zoning ordinance, we consider that to be a 3-story. Staff did provided a definition for what is story and what is a basement. And if we looked at that definition, we concluded that this is a 3-story house.
Mr. Melnick.
I noticed, as was said, that the plat with the proposed house, it says proposed 1.5-story stucco house. Is that any significant here? Because if the plans, my understanding has been the submissions need to match what's being applied for, but what if any significance would that have? And is what I'm looking at the right one? It's 1.5? Okay, this says 1 story.
So they put the 2.5.
So I see the one on the reverse side. Let's see.
I believe that was the plat of the prior house.
Well, it says proposed, but where on the plat on the opposite side does it talk about how many stories?
It only gives the existing. It says existing 1-story under construction. And then I believe it says proposed 2.5. And so what Sam is basically saying, in our analysis, based on how we define half-story and story, the half-story that the surveyor is proposing, we count as a full story.
Okay.
So our determination is that it's 3 stories, regardless of what the surveyor is calling it.
Is it a basement and 3 stories?
I don't know if there's a basement.
Yeah, it has a basement.
Okay.
It is a basement and 3-story. Yes.
I see. Thanks for the explanation.
Thank you. Other questions or comments?
Go ahead. This is just a comment to staff. I noticed that in the section where you talk about comments from neighbors, you mentioned 174 from the previous meeting. I think if we're going to go that way and put things into this staff report from previous actions, it should be balanced, and that therefore you should say how many letters you received in opposition and the fact that there were speakers in opposition as well, and not just that what the positive side was.
Also,
or not include it one way or the other.
My recollection when we looked at a lot of the addresses were that they weren't anywhere near the property.
And they really weren't nearby neighbors. So anyway, just for future, it would be more balanced if you're going to refer back and you give the complete record, or not refer back at all. We'll remember it. There's a retaining wall called for. Is that entirely on the property? Is that retaining wall called for in the back? Where did I see it?
Retaining wall. Yes, there is a proposed retaining wall which supports the rear deck.
Okay.
supports the platform above.
And that's entirely on the property. It does not abut.
It's on the property. Yes.
Thank you.
Mr. Owen.
Thank you, Madam Chair. This lot is smaller than the required size for a buildable lot in this zoning category, is that right?
Yes.
In the caption for our item, I did not see any relief being discussed as to that requirement. So I didn't see, I saw the relief being granted from the setbacks, but I didn't see in it a recitation of relief being granted for the lot size. Am I missing something, or is there a reason why relief from the lot size requirement isn't mentioned in the case caption? I could very well be missing something. But what allows this, if we say yes, why can this building go forward if we have not explicitly granted relief from the lot size requirement?
Because we say we can't.
I think you're correct. I think this is a vestige of the previous review where it was an existing building, and the only issue was the setbacks.
Okay.
Variance was for the setbacks.
I have some other questions while we recover from that answer. In our material, several neighbors have talked about their concerns about the sidewalk and utilities along the front of the site. And I understand we have a DES staffer here with us tonight. And I'm wondering if DES could talk about, were this variance to be granted, what would the county's plan be for appropriate sidewalk and utilities in this vicinity?
Mr. Owen, the department and the county do not have the authority to impose requirements on by right development or development that is done as a condition of variance. What I provided the board was an exhibit I put together this afternoon that shows perhaps why that gap exists between this house and the Heidelberg Bakery. Heidelberg Bakery was built in 1988, and at that time the county required the widening of North Culpeper Street in the alignment it is today from Lee Highway through the frontage of the site, and that project was also built as a matter of right. The county requested that the owner of the Heidelberg property grant to the county an easement for public street and utilities purposes, which they did. It's 7.5 feet wide, and it encompasses the sidewalk that was built along Culpeper Street. On the plan that was approved by the Department of Public Works back then, there was a proposal, or at least a notation and a line drawn, and it's on the second sheet of that exhibit. It's that black and white plan, hand-drawn, which was how we did them back in those days. The engineer for the Heidelberg Bakery drew that. I highlighted in green what was to be a connection from the end of the Heidelberg sidewalk that was going to be built on their property to the sidewalk that has been in existence just south of this property and in front of the property under the consideration for the variance. That connection, if you look at that note, or at that green little strip I colored on that plan, you will see just to the bottom right of it, it says connect to existing sidewalk or walk, and it says obtain required easement prior to construction. That plan connection, at the time we approved the plan, and we can't go back and find the people that put that on the plan or why it was put on the plan that way, but everybody understood, including the owners of Heidelberg, that to build that small connection, or even one today, would require an additional easement for public, at this stage, of public sidewalk purposes on the property under consideration tonight. Since this was a project built by right, there were no special conditions on the Heidelberg property to bond or to make sure it got done. It's simply, my speculation is that they never got the easement or were not able to get the easement from the owners of then owners of 2116 North Culpeper, and the connection was not made. In the, if you look at the street view photograph that's in the last page, you can see the gap that exists today. If you go to the front of the exhibit, which is that photograph with the property lines drawn, this is a very close rendition of where the property lines exist today. The public right-of-way of the street in front of 2116, it's pretty much right at the back of the sidewalk. And you can see the extension of the easement that touches the property in question and how a proposed 4-foot sidewalk would look like today on both properties. If a sidewalk were to be built today, whether it's voluntarily or through an NC project, that the county could pursue, or the neighborhood could pursue, it would require two things. One would be an easement on this property that would need to be given to the county, and in such instances when there is no subdivision or any type of other consideration for this kind of request, it would have to come to the county as an offer of dedication that is presented to the county board by the applicant, and the county board would then approve that dedication with whatever conditions are attached to it in a board hearing as an acceptance of that easement. The second thing that has to happen is, in order for that walk to be built today with today's standards for at least ADA compliance and at least the grade that would need to connect it to, it's fairly flat, as you can see in the photograph. But it would require the removal or reconstruction of the Heidelberg Bakery driveway and the removal and reconstruction of the driveway that it accesses this house today. The applicants would need to get permission from the Heidelberg property to both access that gap of unbuilt sidewalk or wherever the landscape and the green space is between them, mostly on the Heidelberg property, and permission to take down or replace or remove their driveway entrance. And that's something that would need to happen between two private property owners and the county, or not the county, but then a sidewalk could be built. Then we can talk about how a sidewalk may be built and who would build it and how can we achieve it. Of course, the applicant could say, I'll do it all. I'll get the easement from, or I'll convey the easement to the county. I'll get the permission and the rights to go through the Heidelberg property and rebuild their drive and have to happen and get all that done. Would need to obtain permits, right-of-way use permits from the Department of Environmental Services for the construction of that sidewalk so that it can be done the way everybody else builds sidewalks or improvements in the public right-of-way. And those would have to take place. Somebody will have to make that decision to do it. Now, I am not here to recommend on who should do it or how it should be done. There is one mechanism that if no one agrees to do it or it can't be built as a condition of this variance request, the only option that the neighborhood would have, or at least the one I know of, that they could see that how can that gap be built, that missing link be built, would be through a neighborhood conservation request from Highview Park through the neighborhood conservation efforts that come up periodically before the board, and ask that that be built in their missing links project, or as a project that then the county would build to make that connection. So the only options, as I stated, would be a voluntary connection with a lot of strings attached that I described, with easements and permissions from owners of not having to do anything with the variance, or an NC project that could be developed and through neighborhood conservation requests to Arlington County.
Thank you. Questions?
Thank you for that very thorough explanation. If they were to go through the Missing Links program, they would need permissions from the owner, but not easements?
They will need whatever the project would dictate. NC projects, when they go through engineering design, have to consider a number of things. Today, we apply standards for ADA on almost anything that is built. The driveway standard for compliance with ADA is very comprehensive. Neither one of these two driveways meets that requirement. The community may want to see a wider sidewalk. It is a very tight sidewalk in front of this house, but you sometimes have to live with what you have and just make the connection. So those were the things that need to be considered in the project. The county can ask, if it was an NC project and these owners are willing to go in a contribution or whatever, would have to convey to the county the necessary easement to build a sidewalk on that little corner of their property. Heidelberg may also have to participate in allowing us, or at least agreeing to have their driveway and their property disturbed simply to build that small sidewalk to attach to their driveway on their property within a county easement.
Construction easement.
It could be an access easement. It could be whatever they would like, or sometimes just a regular permission that is done through an agreement without an easement. It is simply, we'll let you come on our property with your contractor to build it, and when they're done, that's it. Can't come back anymore. Something like that.
Thank you.
You're welcome.
Thank you. Other questions or comments? Mr. Smith.
To the engineer, looking at this plat, what is the date of this?
The drawing you're looking, the black and white rendition of that plan is 1988. That was.
The note by the green area, Prop 4, connect to existing walk, obtain required easement prior to construction. That was written in 88?
Yes. Every note that you see here in black and white was taken from a photocopy of that plan. And the only thing I added to it was the red line of the lot and highlighted that little piece of sidewalk in green.
So that wasn't done, though?
It was not done.
So Heidelberg didn't complete the construction according to the building permits they were given, right?
It was not a condition of a building permit. It would have been a condition of the approval of the civil engineering plan, which is one of the sheets you're looking at, part of.
Which they didn't comply with.
They did not build it as was approved on the plan approved by the Department of Public Works. Now, we can all speculate that how it didn't get built, but the only thing that made sense was that they probably did not or could not get the easement. I'm not going to go further with that.
Okay.
Yeah.
Thank you.
Madam Chair,
Ms. Malice.
you reminded me with that red square. One of our speakers, this is to zoning staff, one of the speakers noted that the outline of the parcel here is incorrect. Do you agree with that?
Do I agree with that? Oh.
For zoning staff, I'm sorry.
The plat submitted, the outline.
See, the picture that we're looking at, is that accurate according to the plat? 'Cause a speaker has more than once noted that all of that land does not belong to the applicant.
Back about 20. That's not theirs.
It's not accurate. What I try to do is to try to mimic what is on the plat. Which
The fence, as opposed, and the fence really isn't the property line. The property line is about, looks like maybe 20 feet in front of that fence.
no, it's not accurate.
It's an approximation.
It's an approximation.
Madam Chair.
Adjust that so that doesn't become an issue every time this comes up.
Other questions?
Madam Chair.
Mr. Owen.
Just thank you for that great explanation of the sidewalk. I'm a little unclear in your rendition. Was the Heidelberg Bakery required by any county entity to build the sidewalk that they built?
It was only. The project was built as a matter of right. The engineering plan that was approved includes that connection. Everything else was built but the connection by Heidelberg.
But the rest, are you asserting that the rest of the sidewalk was built purely voluntarily by Heidelberg? Is that right?
They
were
agreed to
under
do
no
it voluntarily on their civil plan on a by right project, yes.
Because we also heard from Mr. Lawson that they got a variance.
But I am not aware of the variance for Heidelberg and any of the details of that variance.
Okay, so
But
I
it
think
would not have been tied at that time to something that we approved in Public Works for construction of that sidewalk.
Okay, I'm a little bit curious and this probably is not a question for DES, but for zoning, if there's any more information about how that sidewalk came to be, I'm a little bit skeptical that that sidewalk was utterly voluntary by Heidelberg, and I would be interested to know what the mechanism was for the terms and conditions of that sidewalk. Maybe it was, but if not, I could see there being interest in at whatever stage or whatever division of the county government might have required a sidewalk in front of Heidelberg, whether it could be invoked here as well. But it sounds like, and the other thing is, just to clarify my thinking on this, is you did describe that one option is somehow that this applicant could do all the work, right, to get necessary easements, to get necessary permission, both from the county and from the neighbors, and then actually construct a sidewalk, and that's sort of one path.
That's one path.
And then another path that I sort of imagine is that they might agree formally to cooperate with whatever somebody else does, whether it be Heidelberg, whether it be the county, but a much lower lift for this property owner might be to say, if someone wants to build a sidewalk there, it's not going to be me, but I'll sign whatever you want to sign at no expense to me, for the sidewalk to be built. So I think it might be, I could imagine the neighbors and the applicant being interested to know what is that list of things that an applicant would agree to, just to agree to stay out of the way. What needs to be on that list to say, if the county and the taxpayers want to do this, this is what we're agreeing to so that it can happen. So that's not necessarily a question for tonight, and you may feel like you addressed it, but that's sort of what's on my mind. Because I'm not sure that, I don't foresee that we're going to wind up with a completed sidewalk at the time that this house is built at the expense of the applicant with them organizing it all. I just don't see that being a path that people are going to want to go down. But having them agree to that, to other people building it, I could see people wondering how hard that would be to do.
Okay. You want a comment on that?
You're welcome to, but I'm really not, I'm mainly saying it for any future meeting we might have.
Okay. I don't have any comment on that.
Other comments, questions?
I have none.
Mr. Wong?
Some of the speakers in opposition to this project asserted that there is a by right option here. And we just established that there isn't a by right option because the lot's too small. But if the lot size requirement were waived through a variance, would there then be a by right house available to build on this site?
The property owner could adjust the size of the house so that it doesn't need placement, relief for placement.
Mm-hmm.
So that's possible.
Okay.
But they would have to come back here for something.
Because
of the lot size.
Right, because of the lot size. But they might have a buildable lot if we said the lot size is forgiven, now it's up to you. And that could be sufficient for them to have some value in the property. Is that right?
Yes.
Okay. Thank you.
Madam Chair.
Mr. Smith.
Kind of to go back to Mr. Owen's earlier question or point with respect to the absence of advertising the need to grant a variance due to the substandard size of the lot. Are we in a position where we actually have to re-advertise?
It looks that way.
I think so.
I mean, that's what we've kind of concluded out of this end. And thank you again, Mr. Owen.
Madam Chair?
Can we see a direction in which we're moving?
Well, and that's...
Ms. Malice.
I do think that we're going to have to re-advertise this, so I think that the best thing we can do right now is to put on the table what we'd like to see when this comes back, or how we want concerns addressed. For instance, the concern about, neighborhood outreach and, civic association outreach, that could be addressed in a deferral period. But the other thing regarding the size of the structure, I think that we would like to see a by right option here that we can then compare to see if it's reasonable, because that is basically what the neighborhood comments have suggested that the applicant do. And so I think that we should explore that option to see if that in fact produces, a workable result. So that would be, so when this comes back, I would be looking to see if what that looks like.
And Madam Chair, just to kind of follow, if we're going to go in that direction, I want something to be built on the property. I'm kind of where Ms. Jones is, the realtor, and I think the neighborhood wants something there too. I think that they've invested a lot of emotion and energy, and I know Ms. Keith has certainly invested a lot of money. So I'm going to be supportive of something. To the degree that a variance for setbacks is needed, I don't know, or a use permit after the variance then is given.
There's no use permit option in this district.
In that district, right?
Yeah.
Sorry.
What happens? What does that mean? It's all variance?
So when that comes, I'm going to be kind of in the same mindset as Ms. Malice, looking for the least, the smallest request for a variance with respect to setbacks possible, given the applicant's obvious plans to go tall, and to maximize the use of the space. So that would be my thinking in the future when we get something before us that we can act on.
Mr. Melnick.
Okay, for the record, I'm in agreement with what I've heard. So, just setting forth the different issues in more detail. And also, an outreach I think will go a long way, but the other test is, for this variance, is that it not be a substantial detriment to adjacent property and nearby properties. And, and that's important to me because there's a lot of objection. At least people saying they need more time to think about it. But if anyone has anything to say about that, then I'd like to hear that. But hopefully with the outreach, that sort of thing can be overcome.
Mr. Irwin.
I think it's difficult for me to imagine not voting for relief for the lot size. It seems a classic meeting of the standard for hardship variance. As to granting relief for setbacks, Mr. Lawson has made an argument about. He's made several arguments, which I don't think are completely ridiculous, but so have the neighbors, and so Mr. Lawson knows that I sometimes use understatement. So I don't mean anything disrespectful by that. But to my mind, if we're going to waive the lot size requirement and nothing else, then my inclination would be to have a variance that's pretty clean, right? That just says you're 100 square feet under the lot size, go build a house by right, and that's that. And that would leave potentially the community with a lot less control than they might get if they work out some variance conditions voluntarily with the applicant. And the applicant might have more incentive to do that if they were granted some relief on the setbacks. So what I'm pointing out is it seems to me there's some room to maneuver for the people that have been before us tonight, that the applicant might be interested in agreeing to some conditions that, and I guess part of it also is that it seems like some of the neighbors have expressed a certain amount of exasperation with not having a clear understanding of where does it go from here. Can we expect the applicant knows what's required of her at each step, that sort of thing. And it's not uncommon to have variance conditions that set forth, you'll do this, and then you'll do that, and that will happen, and this will happen, and you will or you won't use this method of accessing the site or construction or whatever. And so there, I just think there's an opportunity for trading between neighbors and the applicant that might change their view of the application. Those are just some of my thoughts. But I think in terms of what I would be inclined to grant almost no matter what, it's clearing them on the lot size. But I think I would be skeptical of doing more than that myself.
Is that within the scope of what we're addressing?
I don't think I understand the question.
Well, the variance is very specific with regard to setbacks, et cetera. And you're suggesting not including setbacks, but simply relief for the substandard lot.
At a future meeting.
At a future meeting.
Okay, well, but this is the hand we're dealt now, so how do you get from here to there?
We can't, we have to,
I don't think we can act on this one at all.
this has to be re-advertised.
Okay. Can I have a motion?
Madam Chair, just to follow up on Mr. Owen's good suggestion, ordinarily I think I would suggest that there's some compromise among the parties, and that compromise gives all parties more control, and that's, I think, pretty standard guidance that we give when there's disputes among neighbors. I think some of the neighbors are very skeptical about their ability to work with this applicant productively, and I think this is an opportunity for the applicant and her counsel to decide what their strategy is going to be regarding the neighbors, because in order to work with neighbors, you have to actually invite them to talk to you and to face-to-face meetings and having a civic association meeting and talking specifically. I know there's a lot of bad things have happened, but now we're talking about, can we shape this project to the benefit of the neighborhood? But it really is incumbent on the applicant to be willing to have these conversations. And if there's no evidence that these conversations are taking place and that there's been no, outreach or ability to try to compromise, then that affects how.
We offer.
So,
if this means that no more discussion, if what you're saying is you're done with discussing,
We'll meet anytime.
okay. So I mean,
We can't meet with people that won't meet with us.
Ms. Malice? Madam Chair.
What I think we have to keep in mind when the next civic association meeting is, and to what extent there's anything to share if you're starting over with a different kind of advertisement, a different kind of project. So it's not something that's going to happen quickly. Mr. Owen?
Madam Chair, you said what I was going to say.
Oh, well, wonders never cease. Okay, can we move on?
Madam Chair, it would be my inclination to defer this, move that the Board of Zoning Appeals defer this project to its October BZA hearing.
Second.
Moved and seconded to defer the project with the guidance given by the board to the October BZA meeting. All those in favor?
Aye.
Aye. Thank you. Next case.
That was pretty shocking that we can't even act on this.
Case number V-11238-17-VA-1. A variance request by Douglas Marshall, the owner, to permit a main building footprint of 35.7% and total lot coverage of 47.9% for a new two-story addition with attached garage in the R8 zoning district on premises known as 6100 31st Street North. Staff recommended that the board accept the applicant request to defer the case to the September 20th, 2017 hearing.
Madam Chair, is this one are we on the variance first?
Yes.
Madam Chair? I would move that the Board of Zoning Appeals defer V-11238-17-VA1 and its associated use permit application V-1123817-UP-1, both to the September 20th, 2017 hearing.
I'll second that motion. Both parts of it.
Moved by Mr. Owen, seconded by Mr. Smith to defer both the variance and the use permit to September 20 hearing. All those in favor?
Aye.
Aye. Thank you. Next case.
Case number V-11258-17-UP-1. A use permit request by Kimberly Harris to permit a setback of 2.1 feet from the wall of a shed to the rear property line instead of 10 feet as required, and 1.5 feet from the eave to the rear property line instead of 6 feet as required for a shed in R6 zoning district premises known as 5010 14th Street North. Staff recommended that the board adopt a resolution granting the use permit with a setback of 6 feet to the rear property line instead of 2.1 feet as requested, and 5.4 feet to the eave instead of 1.5 feet as requested. Staff provided an alternative resolution should the BZA wish to grant the use permit as advertised with conditions.
Thank you. Questions? Hear from the applicant?
Good evening, Madam Chair and board members. You may remember me from the May board meeting. And just a quick recap on that. I guess my shed location's not up. My shed's not up.
Move the picture. Slides, please.
So I had I have an existing shed on my property and applied for a use permit. In my proposal in May, I recommended pulling that shed 6 feet off the lot line at its current location. One of my two neighbors on the adjoining rear lot had objected to that location, and even though I had numerous discussions with them prior to coming to the May meeting, I was unable to resolve our differences. And his main concern was he could see my shed from where he parks his car, and he finds it unappealing. At the May board meeting, you all encouraged me strongly to have further discussions with all three adjoining property owners and try to come up with a resolution. And so I bring a resolution to you tonight. I've had multiple individual meetings with my three adjoining lot owners, and they've been very patient with me. The one who objects to the location has been the most patient with me, I'd say. But the other two, which have less interest in the project, are, I feel I've been imposing on them. So I appreciate their accepting my need to talk to them about this shed location. So my current proposal moves the shed approximately 10 feet to the east of where its current location is. And this was actually a proposal proposed by the, oh my gosh.
You got a minute.
Sorry, go ahead.
Oh, by the western rear lot owner. And it's the furthest location that neighbor can have from where he parks his car that doesn't then impinge on the other rear lot owner's property where there is no opposing shed. My neighbor has a shed that opposes my shed. I understand that the zoning staff's preference is that it be 6 feet off the lot line, but unfortunately, the location that my neighbor has requested puts it directly behind my addition and my big bay window. So what that would mean is that my shed is now looming in my bay window if it was that much closer to the house, which is about 5 feet closer to the house than I'm currently proposing it. And I did bring picture to show
Sorry.
the difference between where my bay window is, where the current location of the shed is. What it would look like.
Madam Chair,
Oh, am I done?
Did she finish?
I have a question for the, I was just going to ask the applicant if she had anything to add to her statement.
Go ahead.
Oh, thank you. So where the shed would be if it had a 6-foot setback from the lot line would be approximately where you see the edge of the azaleas. So it would be much closer and kind of be visually unappealing for us from our house. So that's why we're proposing the 2-foot setback. It was kind of conditional on our, on agreeing with our neighbor that we put it directly behind the addition, which is the narrowest part of our yard.
Okay, thanks. Ms. Malice.
So which proposal did your neighbors agree with?
The proposal 2.1 feet from the rear lot line, and it's now moved 10 feet over from the proposal that I had in May. So there's a signed document that's.
So are you agreeing with the staff
No.
recommendation?
No, you want the alternative as advertised.
Okay.
2.1.
Am I correct in understanding that only staff wants it moved 6 whole feet back, and everybody else is okay with it being 2 feet back? Is that right?
Everybody accepts the location as I proposed in my use permit application, yes.
And by the way, you're to be commended for your additional effort in reaching out to your neighbors. I think that's likely to be very fruitful for you tonight.
Thank you very much.
Any other comments, questions? Motion?
Chair,
Mr. Owen.
I'd like to move the alternative resolution. In the matter V-11258-17-UP-1, I move, I move the Board of Zoning Appeals adopt the attached alternative resolution approving the use permit as advertised, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Ms. Malice for the alternative resolution. All those in favor?
Aye.
Aye.
Thank you. Next case.
Case number V-11262-17-UP-1. Use permit request to permit a setback of 16 feet from the front porch base instead of 25 feet as required, and 15.5 feet to the porch eave instead of 19.5 feet as required from the 18th Street North right-of-way, and to permit a setback of 15.1 feet from the wall instead of 25 feet as required, and a setback of 14.4 feet from the eave, and 12.9 feet from the attached planter box instead of 21 feet as required to the 18th Street North right-of-way, and to permit a setback of 16.5 feet from front porch from front porch base instead of 21 feet as required. Instead of 21 feet as required, 15.3 feet from the porch eave instead of 19.5 feet as required from the North Brand Street right-of-way, and to permit a setback of 2.5 feet from the wall of a detached garage instead of 10 feet as required, and 1.3 feet from the eave instead of 6 feet as required to the rear property line, and 18.4 feet to the wall of the garage instead of 25 feet as required, and 17.9 feet to the eave instead of 21 feet as required from 18th Street right-of-way for a new 2.5-story dwelling with a detached garage in the R6 zoning district on premises known as 1801 North Bryant Street. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions? Please.
Hey, my name is David Springberg. I am the owner of 1801 North Bryan Street. I too was here back in May, and at the time, a couple neighbors had some concerns about a suboptimal location and structure of my garage, and I can't disagree with them. If you go to the plats, it kind of gave Sam the history after Amanda left, but the original plan was to put a one-car garage with access with a one-car driveway off of 18th Street. When we got close to the BZA hearing in May, Amanda was concerned that DES would not approve that because of the location of the driveway close to the alley that runs behind the house. So the engineer came up with an alternative which was clearly suboptimal, which was a two-car garage accessed off the alley. That didn't make anybody happy, myself included. The structure was too big, the access was going to be awkward, and it was in a location where there was an existing tree in my back corner that my neighbor to the rear on the other side of the alley, provides her shade. We took some time, we went back. The next morning, we all met out there, and we kind of worked it out almost immediately with regard to the driveway and the garage. We went back to the original plan, which was to put the garage, a single-car garage with a one-car driveway off of 18th Street, and sliding that garage forward 10 feet so that there would be room for a tree. The existing tree, we had two arborists look at, one prior to the board hearing, one after the board hearing. They both come to the same conclusion. The tree is in terrible shape. It's a V, it's rotted in the middle. The tree has to be, come down regardless. It's got no roots on the alley side. But I agreed with the neighbor to plant back a poplar, plant some additional screening trees, and I wouldn't take it down before Labor Day so that she got to enjoy another summer of shade. In addition to that, with the access, Tom to my left, Jason to my right, so they all use this alley. It's an unimproved alley, but it's used on a regular basis with most of these neighbors. The gravel for the alley is not really where the platted alley is, and there was concern that my property would continue to erode into the alley. Very strongly that we need to delineate this alley so that the access is never encumbered. So I also agreed to do a retaining wall starting at along my back property line so that the 15 feet of the alley is properly delineated. There's also going to be 110 feet of new sidewalk that's going to come along the whole length of 18th Street. I know you have a letter from my neighbor who's concerned about visibility and pedestrian safety. 18th Street does not have sidewalk on either side. It doesn't have curb and gutter on either side. Bryan Street has a stop sign. Barton Street has a stop sign, but there is not a stop sign between Wayne and Adams. So I understand people's concerns that, in the morning, people come off of Lee Highway, they turn onto Bryan, or they turn onto Barton, and they're cutting their way up to come here into Courthouse. So I can't control everything that happens on the street, but I can control what happens on my little corner. So I think we work together. I think my neighbors are happy with the garage placement and the trees and the plantings. And I'd be happy to answer any other questions.
Thank you. Questions for the applicant?
Madam Chair?
Mr. Owen.
Thank you for working with your neighbors on this. It sounds like we're in a much more peaceful place than we were last time. I'm interested in the replacement tree question. Mm-hmm. You're not planning to live in this house, right? You're planning to
not
resell it. But you've agreed to replant the tree, and I'm kind of interested in seeing if maybe we could put that in as a condition of the use permit, that there would be a poplar tree replanted. Sometimes what happens with new tree plantings in these sorts of situations is that the tree gets planted, and then 9 months later it's dead, and well, they planted the tree, so I'm thinking that if we were to include a condition like that we would include some period of time during which the tree would need to be maintained, kept alive.
That's no problem.
Do you think 10 years is a reasonable amount of time?
In previous situations where I've had not use permits but URDs, I've put up a cash bond, DES for certain trees or certain improvements. I'd be happy to do that. There's a tree that I swore to protect with a URD in my neighborhood on 14th Street, and DES is holding $5,000 somewhere that I'm not sure anybody knows where it is exactly. Maybe Mr. Araya does, but
Does that ever expire?
I don't know. I think it's 10 years, and the question is, well, in 10 years, who's going to know where to find this?
Right.
But for what it's worth, after our May meeting, I met with Liliana, who said, go ahead and submit your plans, how you're going to do it. And the tree is shown on the tree preservation and planting schedule, so it shows that it's going to be there.
Yeah.
And generally we have to guarantee. My landscapers will guarantee a tree for 2 years. Again, I can't control if a neighbor removes a tree. It can be a condition of the use permit that there will always be a tree planted there.
Right.
And I have no problem recording that with anyway.
Okay.
I don't know how you would work the mechanism, but I'd be more than happy.
There comes a certain point at which generations change, conditions change. Maybe there's a poplar blight, and so it needs to be replaced with an oak, right?
Right.
So yeah, so I don't want it to go in perpetuity, right? But a nice, good long time to make sure that it's a good, hefty tree by the time we stop protecting it. All right. Well, thank you for answering that question.
Other questions? Thank you. We have 2 speakers. Thomas Hunter.
Good evening, board. My name is Thomas Hunter. I live, my wife and I own the piece of property on the north side of this house there, in the former White House. This way is north, with a red pickup truck behind it. And originally I voted for a disapproval of this, but I have had some pleasant conversations with Mr. Stringberg, and I'm now on board. That's the short version. Anybody want the long version?
Excellent. We encourage short versions. Excellent. Thank you.
Thank you for taking the time to come see us.
And then Susan Charlton.
Good evening, and thank you for the opportunity to be heard. I'm the neighbor who wants the tree. I live diagonally across the alley, so my backyard faces the developer's corner lot. We have compromised and talked about a number of issues, and we have come to a lot of resolutions that work out for everyone, and I'm very happy to say that we've been able to do that. There's one issue left for me, and that is the setback along 18th Street. The zoning ordinance requires a 25-foot setback. The developer is asking for 15 feet. That is a 40% decrease. The hardship, he claims, is that he can't build as large a house as he wants on this lot, which is standard 5,500 square feet for this neighborhood, within the prescribed setbacks. One thing I would say is that just because you can build a big house doesn't mean you should. I think the safety issues on the corner are an issue, and I also think it is not as consistent with the neighborhood as the developer would like you to believe. All of the houses, all of the new construction in Lyon Village on corner lots, which are zoned R6, are within that 25-foot setback. Some of them had to be pretty creative in getting to their lot coverage amounts, and but they stayed within them. This is going to be new construction, and it's going to change things. And I would submit that this is not just a dispute between neighboring property owners at this point. This use permit request is emblematic of a problem the Zoning Appeals Board will continue to see every time a developer wants to build a huge house after tearing down a little house on a corner lot in an R6 zone. The zoning ordinance exists for a reason. Many reasons, in fact. Safety, consistency with the neighborhood. If you give me 15 more seconds. Variances and use permits are granted as exceptions to the rule. If there's a problem with the rule, it's not to be resolved on a piecemeal, case-by-case basis every time. They should go to the county board and get the rule changed. Thank you.
Thank you very much.
Chair,
Mr. Smith.
Question of Ms. Charlton, maybe two. The photograph that we're looking at, is the blue house yours?
No, the blue house is gone. My house is between the blue house and the white house on the corner. That square roof, that's my house.
Thank you.
Yes.
I wasn't sure if that was connected to the other. 'cause that-
No, the blue house is gone, and there's a very tall house next to me now. They're downhill, but they tower over me. But they stayed within the zoning requirements. They built it tall, but within the boundaries.
Mr. Melnick.
Okay, so as you may know, what we're doing is looking for compatibility. And I understand what you're saying, you know, and it's definitely our interest, you know, not to just have, you know, sort of a runaway situation, you know, people getting closer and closer and closer, and even feeding off other ones that are closer. But there's a listing here, and I don't know if you've been able to see it. I believe it's 6 properties in the area, and what the staff does is they, you know, take a sort of a survey in the area, and they give us a sample, and that lets us know, well, what is out there, you know, what are we trying to make this compatible with, and that's everything from 18.1 feet to 12.8 feet, and so when I see
I'm sorry, go ahead.
Yeah, well, when I see the 12.8, especially the, you know, a few that are 14, this does seem to be within that. And see, that's, so I'm trying to square this with what you're saying.
My point is that all of those homes were built before there was a zoning ordinance. This is going to be new construction. All of those homes built in 1924, 25, 29 are 1.5, or at most 2 stories tall. And they don't exceed most of them don't even come close to the lot coverage requirements. There's one on the corner of Adams Street, I think it's 1801 Adams, that has an addition on it. I think that's the approval that was granted there. But the addition went off the back. It did not encroach on the side on that 18th Street variance there, beyond where the original house had already been.
Okay. Thank you.
Thank you.
Thank you.
Can I just make a couple comments? If you look at that picture, the property behind me is Mr. Carrier's. He's on the other side of the alley. That property is 8 feet from the street. It's 16 feet from 18th Street. The porch is 8 feet from the road. Across the street from me, the side yard setback is also 15 feet. It's a corner lot. It's a 50-foot wide lot. You know, an allowable footprint is 16 feet in width, and 16 feet is 16 feet is not a feasible dimension to build a house. The footprint, the allowable footprint, as crazy as it sounds, is 2,700 square feet, or 2,772. I believe my footprint is 1,536. I'm well below lot coverage. I'm well below, the maximum lot coverage, the maximum building footprint. The house, I believe is properly sized, and we also did a study of the other houses. We looked at setbacks, but we also looked at lot coverage, and not to point fingers or anything, but just all the houses around me are within 200 square feet, one way or the other, of the lot coverage of my home. So,
Thank you.
Madam Chair.
Mr. Owen?
I have a question for staff. You guys heard my exchange with the applicant about a condition for a poplar tree to exist. So I wanted to read you proposed condition language and see what you thought about its enforceability. Applicants agree to maintain a poplar tree in the location indicated on the submitted plans through July 31st, 2027.
Is there any particular reason you're choosing the species?
The applicant appears to be volunteering the species, and it's the same species as what's there, and those are my 2 reasons.
Okay. My only concern is if our recommended species change.
Mm-hmm.
When we're so specific, it doesn't leave a lot of flexibility for that to happen. So maybe adding something, or as recommended by...
Or equivalent species as determined by the zoning administrator?
Sure.
Okay.
You're looking for a fast growing with a big canopy. There aren't a lot of those. Okay, we ready? Any other questions, comments?
Madam Chair,
Mr. Owen.
I would move in the case V-11262-17-UP-1, that the Board of Zoning Appeals adopt the attached resolution approving the use permit, subject to the conditions listed in the resolution, and one additional condition to read, applicants agree to maintain a poplar tree or equivalent species as determined by the zoning administrator in the location indicated on the submitted plans through July 31st, 2027.
Second.
Moved by Mr. Owen, seconded by Mr. Smith with the additional condition referencing the tree.
Madam Chair.
Mr. Smith.
I'd add for Mr. Charlton's purposes or benefit that and really specifically with respect to what Mr. Melnick said, the zoning or the neighborhood compatibility with the neighborhood. It doesn't say compatibility with the neighborhood with those structures that were built after a certain point in time, and it really is kind of compatible when they're at that distance from corner lots. So that's why I support this.
Thank you. Any other comments? All those in favor? Aye. Thank you. Next case, please.
Case number V-11268-17-UP-VA-1. A variance request to permit the development of a lot that does not meet the width and area requirement of the R27 zoning district. Staff recommends that the board adopt the motion to defer the subject variance to the November 2017 BZA hearing.
Chair.
Mr. Owen.
I move that the Board of Zoning...
Interrupt you, please. It appears, though, this is a deferral. We have a speaker.
Oh.
Sorry.
The staff, Madam Chair, the staff reports are posted Friday afternoon before the hearing on the county website. And so that's the first that you could probably find out on your own. Also, oftentimes staff can, if you call them in the week before the hearing, they might be able to tell you, or email them. They might be able to give you a heads up about it. So sorry about the inconvenience.
No, it's November. Thank you. Sorry. Mr. Owen.
Madam Chair, I move that the Board of Zoning Appeals defer item V-11268-17-VA1, as well as the associated use permit V-11268-17-UP1, both to the November 2017 BZA hearing.
I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick for deferral of the use permit and variance to the November 2017 BZA hearing. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11273-17-UP-1. Use permit request by John Dolan, owner, to permit a setback of 0.7 feet instead of 1 foot as required from the right side property line to the wall of an existing shed, and a setback of 6.1 feet instead of 8 feet as required from the wall of the shed to the wall of the main building, and an aggregate side yard of 7.2 feet instead of 18 feet as required in an R6 zoning district premises known as 538 North Oakland Street. Staff recommend that the board adopt the attached resolution granting the subject use permit with conditions.
Questions for the staff? Applicant, please.
Good evening, ladies and gentlemen of the board. My name is William Dolan. I'm the brother of the petitioner who is recovering from cancer, and I'm here by a power of attorney. This is basically about a shed setback. The regulations refer to it as an accessory building, but let's call it a tool shed. That's really what it's about. At this point, I think the board is probably interested. A picture's worth 1,000 words, so I think the board would probably be interested in the picture rather than 1,000 words, the way these things go. This is a blow-up of the land survey from last month, and this yellow is the street, and the orange is the house, and the subject shed is here in pink. Notice that there's a large tree right here, 24 inches. This is all in the file. To make a long story short, the fence is not at the invisible boundary line. The fence is on the property of the next door neighbor. So one of the issues is this accessory building has to be at least 1 foot from the invisible boundary line. It is more than a foot from the neighbor's fence when this was put up 20 years ago. My brother bought the house in 2007. At the time, the shed was 10 years old anyway. So this shed has been in place. The neighbors have no objection to it, but it is non-conforming because one end of the shed, according to the survey, is 3.6 inches. In other words, 0.3 of a foot too close to the invisible boundary line that we weren't aware of. So instead of being a foot, there's 0.7 feet according to this survey, even though in one of the pictures we gave, the fence is 16 inches from the shed. Now, the shed is not perfectly parallel. This side of the shed is not perfectly parallel to the boundary line. So we've got more than half of the shed in compliance and part of the shed a few inches off. So one of the issues here is, can we please leave the shed in place? It will cost, there's a chain link fence down here that would have to be taken out. The tree would have to be taken out. It'd be very expensive to demolish it. The chain link fence would have to be removed, including the posts. The shed basically is uneconomical to move in any way. It's not a movable shed. It's a tool shed. The other issue is the distance between the house and the shed. That distance is supposed to be 8 feet by the zoning regulation. It turns out the distance here is really 9 feet. Let's look at a blown up version. This is 9 feet from this garage to the shed face. However, and the drawing and the regulation says 8 feet, and it shows building here, a shed here, has to be at least 8 feet in the regulations. However, these corners, at the closest point, this is 6.1 feet. So this entire building is more than 8 feet from the house, except when you read the exact letters of the law, it says no point can be closer than 8 feet. So basically, I guess we could cut off part of the shed, but it's also uneconomical. And so these are the two issues. The neighbors have written letters that couldn't be any better if I wrote them myself. And basically, we'd like to ask that the shed be allowed to stay where it is, not move the tree. It's 2 feet in diameter. It has branches too, so it's really bigger than, takes up more than 2 feet. So the shed can't be easily moved, even if it could be moved. Anyway, thank you very much for your consideration of this.
Thank you. Question?
May I ask you a question? How did you come to be here?
How did what?
How did this case come before us?
Very good question. There was a tenant issue, and the tenant's now gone. The tenant had an extra person at the house, and the people from the zoning office came to look at the house, and they gave us a warning about a citation about the shed.
There was a tenant issue in another house?
Pardon me?
This house. A tenant issue in this house?
The tenant was there, and he had an unrelated person. There's a rule about the number of unrelated people, and then he had a family and 3 people plus 2 unrelated, and that didn't work.
So the shed is collateral damage. Wasn't the original issue, but it became an issue.
I was asked.
Get rid of the tenant, but you want to keep the shed.
Yes.
Got it.
Thank you.
Mr. Melnick.
I'd like to make a motion, if I could.
Please.
Okay. So in case V1127317 UP1, I'd like to make a motion that the Board of Zoning Appeals grant the use permit with conditions as applied for.
Second. Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor? Aye.
Aye.
Thank you very much.
Thank you very much.
Thank you for those visual displays. They were helpful.
Excellent. Very excellent. Thank you.
This pointer, too.
Next case, please.
Case number V-11274-17-UP-1. Use permit request by Jaji and Sujit Bowler to permit a setback of 2.8 feet to the eave and 3 feet to the column base from the right side lot line instead of 10 feet as required, and an aggregate side yard of 10.9 feet instead of 18 feet as required for a new carport in R6 zoning district on premises known as 5207 North 11th Street. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions. An alternative resolution is provided should the board decide to deny the applicant's request.
Thank you. I'm going to ask you a question. In the report, it references a shed, another shed, a non-conforming shed. But we're silent on that in terms of a resolution.
Compliance in granting this?
Is
it off? It's gone. They ripped it off.
Okay. Got it. Thank you. Applicant?
Hi, good evening. My name is Jeff Kelly, and I'm here representing Jagir Bueller, who is in attendance, my father-in-law, and my mother-in-law, who own this house and have since the early 1980s. Over the years, as they've lived in this neighborhood, we've made various improvements to the house so they could continue to live there. As they have aged, it has become more and more necessary to provide something over the driveway that has existed there since the house was built, provide shade, provide protection when they're trying to get in the house if it's raining, and most importantly, any kind of snow or anything that's happening. My father-in-law has a heart condition, cannot shovel snow, cannot clean cars, do those kind of things anymore, and my mother-in-law is not able to do those things either. So the request is that we be allowed to build a carport over top of the existing driveway so that they have a way to get from the car into the house without having to deal with the weather elements that come throughout the year. The other two things I was going to mention, one you already mentioned, was about the shed, which was in the report. It has since been removed. It was there a long time ago, and so it's gone. And
thank you.
No plans are there. Also, I saw in the report that it lists that there are 4 signatures. Since then, we did secure the 5th signature, which we hadn't had an opportunity to do by the time this paper came out. So everyone who is with any proximity of the property, including the two on Frederick Street that will be looking directly at the carport, have signed off on it at this time, and no one in the neighborhood has any problem with it. So.
Is that 1104 on the
Correct,
corner?
yeah. We have secured the signature for 1104, and we got 1110 before, which are the two on Frederick that will face the carport, yeah.
Thank you. Questions for the applicant? Motion?
Madam Chair?
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit V-11274-17-UP-1, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Smith to approve the variance as requested. All those in favor? Aye. Thank you. Next, use permit.
Thank you.
Wait. We still have the use permit.
No.
Oh, sorry. I got ahead of myself.
Okay, we're good?
Thank you. You were good. Thank you.
Case number V-11275-17-VA-1. Variance request by FMH Investments, LLC, owner, to permit the construction of a new two-story single-family dwelling on a lot fronting a public right-of-way which is 26.5 feet wide instead of 30 feet as required for a new two-story single-family dwelling in R5 zoning district, premises known as unimproved lots, lot number 134, on the 1600 block of 11th Street South. Staff recommends that the board adopt the attached resolution granting the variance.
Thank you. Questions for staff? Mr. Owen.
The proposed variance does not have a time limit condition, and I think we've had various practices in the past on whether or not variances such as this should expire or not. And I'm wondering what is our practice and what's the basis for whether or not we have a expiration date for a variance?
I think our standard practice is usually a year.
1 year?
Mm-hmm.
But there's not, the staff is not proposing in the proposed resolution a 1 year time limit. Is that right?
I think the difference that we may have taken in the past is a year is reasonable for construction, and this variance is solely for allowing something to happen because of the size of the adjacent street. Sorry.
Okay. Thank you.
But we wouldn't object.
I guess I'm just wondering about, if there's it's sort of weird because on the one hand, we're granting a variance in perpetuity, right? So for 100 years, they could come back and have the variance spring if we don't put a date on it. At the same time, the variance is conditioned on the particular plans submitted. So it's just, if later there's differences in fire control technology or street design or whatever, it just seems like forever is a long time to be locked into this particular set of plans. There is an associated use permit that they also need to build under that variance, and that has the time limit to come back for further use permits, but the variance would be on the books. So I don't think I get the logic of it, but I'm not picking on whoever prepared it for this particular case because I don't think I get the logic in general for how we handle these situations. So I think for today I'll just remain confused, but maybe someday I'll sort it out in my mind how we're supposed to approach these. Thank you.
Applicant?
Thank you to staff and to the board for your consideration. And without the variance, indeed, my understanding is we will not be able to construct, period, because this I was about to call it a street. It doesn't meet the definition of a street. The alleyway, the thoroughfare, the paved surface in front doesn't qualify as a street. So my understanding of that is why we need a variance, and then the associated use permit for setback issues.
So in essence, the variance declares it to be a buildable lot despite that, issue with the street,
Yes.
which is one reason maybe that it can be longer than a given time as opposed to the use permit, which has a restriction. Okay, thank you. Ms. Malice?
But on that point, I take Mr. Owen's point that this refers to specific drawings. This variance, it doesn't say this is a buildable lot. The resolution says it is a variance to permit construction of a two-story family dwelling, and that it is going to be built in accordance with this footprint shown in the survey. So that really makes it very specific. And so either our policy is to take that specificity out of there, or to just use the same date as we do on the associated use permit. Because you're basically saying that they can have a variance forever, but they've got to build what's here in the staff report. Or
yeah.
Or cut, well, and then the use permit, I'm not even, but anyway, they seem to remain attached. And so the dates seem like they ought to be attached, similar.
So I was just reminded by Mr. Lawson of Article 15.6.5, which basically says if a variance is granted by the board and not acted on or put into effect within 1 year, it expires.
Automatically?
Yes.
Even without it being in writing?
Yes.
Good clarification.
Excellent, thank you, Mr. Lawson. Okay. Any questions for the applicant on the variance?
I'd like to make a motion.
Mr. Melnick.
Okay. I have no objection to this being buildable. It seems very simple. I think it's in the best interest of the neighborhood. That's why I'm making this motion. So I move that in case V1127517VA1, that the Board of Zoning Appeals grant the motion or grant the variance as applied for with the conditions as stated.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith to approve the variance request. All those in favor?
Aye.
Aye. Thank you. Now the use permit.
Case number V-11275-17-UP-1. Use permit request by FMH Investment, LLC, the owner, to permit a rear deck setback of 15.2 feet instead of 21 feet as required, 4.4 feet to the window wells, 4.6 feet to the air conditioning unit, and 4.1 feet to the stormwater planter box instead of 5 feet as required from the left side property line for a new two-story single-family dwelling in R5 zoning district, premises known as unimproved lot number 134 on the 1600 block of 11th Street South. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Questions for staff? Applicant?
Again, thank you to staff for their recommendation and for the board for their consideration. We tried to, we held the building footprint to 28 feet in width, and that allows us to still get a two-car garage, and it's a tight footprint, but it still works. we tried to minimize the encroachments into the setback. But this is characteristic of this street and neighborhood that have rather small lots.
For sure. Questions for the applicant?
Madam Chair,
Mr. Malice.
maybe I'm missing it, but you have a letter from Purdy Green in the, what is her address?
Birdie's address, I don't have that with me. She is across the street and one house to the left.
So if you're looking
It's
out
the,
your window, she's to the left, okay.
so she would be directly across the street from the highlighted lot, and then
One over.
to my right, I don't know about your direction there, the house that is rather long. Yes.
The same.
I approached the other neighbors, both across the street and adjacent, and although I have talked to the people in the white home there to the left, and they seem amiable, I was unable to make further contact with them regarding their position on this.
What about the people that would be behind the, condos?
I did not reach out to the Townhome Association. There is a bit of a natural vegetative, and I don't know if it's a perennial or stream there, a low area, something of a natural barrier there.
For staff on that point, would the condo association or individual unit owners have been notified of this variance and use permit?
It's whomever is listed in the real estate records. So whatever adjacent property owners.
So it'd be
and the
unit
RPCs,
owners.
Yeah.
Unit owners. So there'd be one, two, there'd be,
If they're fee simple.
Only that whole group would, because they collectively own the common area. It would be the association generally.
yeah, we'd just be curious to know how the people that would be behind you, what their view on this project was.
I will note the home to my right here also has a deck with what appears, I don't have their survey, appears to be a similar encroachment, a similar dimension.
Those are the amiable people.
To the right, yes, they did sign.
Oh, the ones that signed?
Yes, two gentlemen signed letters in support in the brick home on the right, the same side of the street.
Madam Chair?
Mr. Muldock.
Okay, so I was, just looking at, what is at issue here, and it just looks like it's what you're asking for is just limited to the rear deck, the window wells, air conditioning unit, storm water cleaner box. So it seems like, in reference to the things except the deck, is it true there's no other places they could be located? Because it just looks like there's an easement, on the right side. There's the deck, and then there's the entryway on the front. But did you investigate, what were your efforts on investigating any other place for those things? Just so that you wouldn't even need the encroachment more than 5 feet. Or I'm sorry, you wouldn't need to be closer than 5 feet on the left-hand side. Did you look into, any different options so you wouldn't even have to ask for those items?
For the window wells and other items?
The items on the
Air conditioning unit, planter box, et cetera.
Exactly, and window wells.
Yes.
Just any efforts on could you explain any efforts to see if there's any way so you wouldn't even have to ask for the extra space?
Yes. I believe that the stormwater box placement is necessary there per the civil engineer, and I guess that's with the roof drainage. The window wells, we need some light, or we're trying to achieve some light into the basement area. And the right-hand side, as you notice, there is a fairly sizable sewer line that goes out of 11th Street down the right-hand side of that property line. It was actually placed outside of the easement that the county has onto this property's land. And over the last 6 months or so, I worked with DES and granted them easement where the line actually is instead of where it's supposed to be.
Okay.
Other questions?
Madam Chair?
Mr. Smith.
I find that these are conditions justifying some relief, so I would move that the Board of Zoning Appeals adopt the attached resolution in V-11275-17-UP1, granting the request subject to the conditions that are listed in the resolution.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor? Aye. Thank you.
Thank you.
Thank you. Next case, please.
Case number V-11276-17-UP-1. Use permit request to permit a setback of 0.6 foot to the wall instead of 1 foot as required from the right side property line, 0.9 foot to the wall instead of 1 foot as required from the rear property line, and 14.8 feet wide trellis instead of 8 feet as required, and 0.9 foot from the trellis to the rear property line instead of 1.5 feet as required for an existing accessory building and attached trellis in R2-7 zoning district on premises known as 2124 North Brandywine Street. Staff recommends that the board adopt the attached resolution granting the use permit request with conditions. An alternative resolution has been provided should the board wish to deny the use permit.
Thank you. Questions? Applicant?
Hi, thank you for your time and the staff's time. First, I'm sorry for going in the opposite order here and building something before getting zoning approval. I tried to keep in consideration the prior footprint and keeping it back or at the previous retaining wall on the back and side. Obviously, I misjudged that, and I wouldn't have if I'd gone through the process the right way. I do have some additional signatures that I think you may already have from the 2 properties that are in the rear. They may not have been on the original submission, but I have those if you like it. And I did a color-coded chart of all the properties that signed off. And I think that's it, really. Thanks for your consideration. I'm sorry?
That would be helpful. We'll pass it. Thank you.
Yes, I'd happy to take any questions or concerns you have.
Red means yes?
Yeah. Everyone who I was able to contact said
counterintuitive.
yes. So no one said no. One of the people in the rear did say, I conceded that it looks a little bit stark back there, and I had mentioned that I wanted to put some greenery back there. So I said if he was in favor of that, he could just write, please beautify, which he did with an exclamation point. So,
Thank you.
Madam Chair?
Mr. Melnick.
Well, first, I'd like to commend you on the design of it. You know, I see, the other designs, but I think yours is quite nice and functional and, quite attractive. So I commend you on that, going the extra mile to make it very attractive. And, just due to how well it fits in otherwise. So I'd like to make a motion, if I could.
Please.
Okay. So in case V-1127617-UP1, I'd like to move that the Board of Zoning Appeals grant the use permit with conditions as stated. Okay.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith for approval. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11278-17-UP-1. Use permit request by Anthony and Christine Kander, owners, to permit a setback of 6 feet to the wall instead of 25 feet as required, and 5 feet to the eave instead of 21 feet as required from the rear property line, for a new 1.5-story detached garage, in R6 zoning district, premises known as 2531 Key Boulevard. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions? Applicant?
Evening, board. Thanks for the time. Enjoy spending the evening with you. So if you look at the picture, the request that we're making, and I'm the owner of the home, myself and my wife, is that the shed in the rear of the house, which happens to fall on Custis Road, which formerly was a through street, but was closed off for metro traffic, would be replaced with a structure that would start at the same place of the current shed, but would be larger and would fit in compliance with the 1.5-story requirements. So under, I think, 500 and some odd square feet, would have the same setback at the rear, given that a 25-foot setback would not allow us to build.
And that's, yeah, I was going to say, it's the dwelling is gone and the truck is there at the moment, right?
Truck hopefully will fit in the new dwelling. The new dwelling would go right where the truck is.
Okay.
Reason for the old shed to be gone was some miscommunication on my part on whether or not I was allowed to build a new structure.
Got it.
Thus, I'm here with a use permit request for the new structure.
Okay.
You have a document inside that shows all of the surrounding homes. Everyone's in agreement with it and happy to have a nice new garage up.
Mr. Owen?
Did you submit any written sign off from all of the properties that abut yours?
I did.
Okay. Did we get that? We got that as a supplemental.
I think I emailed, I think it's part of the ones I emailed to you. Yeah.
I submitted 6 written properties that surround the home.
Okay.
Yeah, I think it's part of the ones I emailed to you. I don't have some of the...
I'm particularly interested in 1714 Bryan Street, which their back, the middle of their back lot abuts it, so that they've signed off.
They have.
Okay. Thank you.
Other questions, comments?
I'll make a motion.
Mr. Melnick, thank you.
All right, so in case V-11278-17-UP1, I would move that the Board of Zoning Appeals adopt or grant the subject use permit with the conditions as stated on the attached resolution.
Second.
Moved by Mr. Melnick, seconded by Mr. Owen for approval. All those in favor?
Aye.
Aye. Thank you.
Thank you all. Have a good night.
Next case, please.
Case number V-11279-17-UP-1. Use permit request by Thomas Mewburn to permit a setback of 1.1 feet to the wall and 0.1 feet to the eave from the rear and right side property lines instead of 10 feet as required for an existing 2-story accessory dwelling, the R6 zoning district, premises known as 1704 South Lincoln Street.
I thank you to the board and to the staff for your positive comments on your report. I don't want to reiterate the things that I've already sent in support of my request, but my main issue has to do with timing and expense. So let me just say that from the beginning, I had no idea that adding onto a garage would be such a perilous journey, but it's been a real odyssey. Part of the reason is because the garage that you can see in the picture up there, I used most of that and added onto it into the property. So I followed the line of the walls where they were existing. And really in following the ordinances requiring setbacks and stuff, there was no way that you could have built this structure anywhere else in the lot. According to the, I just want to say, I mentioned timing. The letter that I got from the zoning office said that they had received a complaint or a request for them to come out and look at the project on the 24th of April, which was actually the week that we had finished the concrete work, the foundation walls and the floor. So we had already expanded the base of the building. And then the zoning department had that, I guess, request for over a month because the letter rescinding our permit was dated May 26th. And by that point, the garage was 75% complete. The walls, all the framing and sheathing and most of the roof was already on. At this point, I have only about 3 days worth of work to finish the garage, so I have a considerable amount of money tied up in what's already sitting there and no real way to meet the zoning requirements in order to be in compliance at this point. So this has taken quite a toll on me financially as well as emotionally. I'm an artist, and part of the reason for building this is the top of it was to be a studio, something I've wanted to have for many, many years. I've lived in Douglas Park for over 7 years. And during that time, my wife and I walked through the neighborhood frequently, looking at other houses, looking at new houses and additions and things to kind of get a sense of what sort of thing was allowable or considered to be the norm. And in that time, I've drawn and redrawn the plans for this garage several times and thought a great deal about the appearance of it. And I've talked to all of my neighbors that showed any interest in it about it extensively and generally seemed to have their support and encouragement in it. So I was really surprised when this became an issue. But let me just say that being an artist, aesthetics is my main concern, and I look at that maybe above other things. And so that's why it's so important to me. I think that once the building is complete, the color scheme and the placement of it, there's a very large tree in the yard right behind this that almost blocks the whole back of the garage from view on that side. You can see the end of the garage from the end of their driveway. But anyhow, I've just tried to keep all of those things in mind, and I think that if anything, this aesthetically would be a benefit to the neighborhood, and most of the neighbors I talk to seem to agree with me. It does blend in pretty well. It's a nice looking building. It's probably nicer looking, and it'll look nicer than my house does when it's finished. But so I just ask you to consider my request for a use permit so I can finish this project and move on with things. So I thank you for giving me your time.
Could I ask you, the original garage was 1 bay and 1 story height?
Yes.
So this is considerably larger.
The garage was 13 feet wide, so I added a second bay, which added another 12 feet of width.
But also a second story.
And I put a 12-12 roof on it so that it would have enough room above it to be useful as a studio. That and the shed dormer which also I put on the inside of facing the inside of the lot, thinking that would sort of minimize the visual mass of the garage from 17th Street, so it sort of downplays the size.
Okay, thank you. Any other questions?
So the staff report says that you were issued the permit.
Yes.
And proceeded, and then you were notified that
Yes.
an error in that.
And I'm a neophyte with permits and building stuff, so I thought when you got a permit, that meant you had permission, so I took off with it and then didn't know until the date that I got their letter that there was a problem. When I did want to point out that anytime within that month, there was no framing done because my contractor couldn't come back during that period. So had I known earlier, I could have stopped way before where it is now.
Okay, thank you.
Thank you.
Thank you.
We have 4 speakers. Mr. Lawson.
Thank you, Madam Chairman. For disclosure, Tom did come by and see me, and we consulted, but he decided to go ahead and do this on his own. But I wanted to submit a speaker slip, and I wanted to share something with the board. Excuse me. This is my garage at my house, and from the edge of the wall to the property line is 1 foot. And the property line is in the middle of this little brick retaining wall. And I just wanted to share with you all that zoning has always, until recently, had always considered it to be to the wall. And so as long as that wall was 1 foot away, they didn't care if you encroached on your neighbor. And this was built back in either the 40s or the 50s by the developer of this subdivision. And so this kind of shows that that's the way that it was in the past. And wanted to share that with you during your all's consideration. So when Tom added to it, it just made logical sense to him to continue the same setback of what was already there and what had been there before. Dropping back to my earlier case, I was wrong about the zoning ordinance. It's 3 stories under zoning. It's 2 under the building code. And so Elena put on her application 2 stories because that's what the architect said. And so there's confusion because you got zoning saying one thing, building code saying something else. Thank you.
Thanks. Lewis Robinson.
Well, it's not part of the record.
In that case. Good evening. How you doing? My name's Lewis Robinson, and I've been a neighbor of Tom for about 7 years. And I'm bottom house of the cul-de-sac, 1713. And in the time I've known Tom, very kind, generous neighbor. And I've lived in this neighborhood since I was 2 years old. And that footprint of that old garage, based on him not encroaching the property lines and just basically shortening up his yard, reducing the size of it, as long as he doesn't have any P2 problems or anything with overland relief, proper drainage and things like that, and architecturally wise, and structurally wise rather, it's sound. The big tree does block it. I like to see him have it. So I'll keep it short, but thanks.
Thank you. Melissa Barron.
My name's Melissa Barron. I live directly behind the Mewborns, and I would like the board to reject this variance for the following reasons. First, this building disregards the zoning requirements put into place to protect the neighbors. This massive garage breaks several zoning restrictions, and it shows. Please take a look at the pictures I have submitted. During this renovation process, mistakes unfortunately were made. The Mewborns submitted plans that exceeded zoning requirements by the footprint size and the height, and unfortunately, this wasn't caught by the county. And as it stands now, this building should be at least 10 feet from the rear property line, and it's only 1 foot. So secondly, while these mistakes are unfortunate, the only one negatively impacted is my family, my husband, my kids, and I, and our day-to-day lives, and financially. This 2-story garage blocks a significant portion of our morning sun, as you can see from these pictures. This building impacts the light in our kitchen, our dining room, and our outdoor space, and it's not even done yet. So now, instead of blue sky out our windows, there's a massive wall. So in this case, today, 9 feet makes a difference. Square footage makes a difference, and the height of this building does make a difference. And if we have to move, this will impact the value of our home. If a buyer walks away because the backyard is too dark or it feels too enclosed, that is a financial loss to my family. Please see the enclosed letter from a local realtor. So while the Mewborns have brought signatures of support, no one to the left or the right of the Mewborns are impacted as we are. Their sunlight and their property value is not impacted at all. And finally, several of our neighbors have signed our petition, as you can see, for the reason that this variance sets the wrong precedence and the wrong tone for our neighborhood. They're not supporting us, they're supporting the neighborhood. They don't want something like this in their backyards. It hovers over our home. The Douglas Park lots are small. And so in conclusion, I'm asking you to reject the current variance. It doesn't follow the zoning laws. It hurts the neighbors that these laws are there to protect and would set a negative example for those living in the R6 zone. We would like the Mewborns to build something, but we would like them to just keep it within the Arlington County zone.
Thank you.
Can I answer any questions?
Thank you. Any questions of the speaker?
Is there anything you wanted to add?
No, this is an unfortunate event. I'm sorry, but this is a new building, and unfortunately, I'm sorry that we're here, but it is causing issues for my family.
Thank you.
Thank you. Mr. Melnick.
So I have questions of staff. I don't know if the chair would want.
I still have another speaker.
Okay.
Can I do that first?
Yeah, that's fine.
Okay. Tarpon?
Everyone always hesitates when they see it, don't worry.
What's your last name?
Parek?
Thank you.
No problem. Well, thank you. I appreciate the opportunity to speak. My name is Tarpan Parek, and I live on South Monroe Street, not too many houses away from the Barrons. And in full disclosure, we are friends with the Barrons. Our kids have grown up together on that street. My wife and I, we're in full support of renovations in our neighborhood. We've seen renovations happening. We've seen houses getting torn down and rebuilt. We've seen garages turned into sort of bigger structures. And we like that for our neighborhood. But having gone through the pain and then canceling projects, we've always tried to do our homework first so that we know what we're getting into before we break ground. We know what the financial impact is and the cost, the impact, the zoning, all the codes. And we always will miss something. I've gone through the effort in our own projects of sitting down with the various committees and boards, so whether it be zoning, the building department, the environmental services department, to learn what we can and can't do before embarking. And so one of the big concerns I have, if this is approved, is a precedence being set that we can make a mistake and ask for forgiveness. And with the amount of construction happening in our neighborhood, a lot of it very well built, we're assuming that all those folks have done their homework and are building within the code and within the rules that are already in place. So that is a big concern of ours. Second is, I know that the 1.5 and 2-story garages are allowed within the certain requirements and setbacks that exist right now. This garage is taller than the homes around it. So to say that it fits within the feel of the neighborhood, it really doesn't. I know they're allowed to do it as long as they sit with the setback. So the height is not a valid complaint. I get that. But to say that what it exists today is conforming to the neighborhood, I don't think is a valid sentence. Thank you.
Madam Chair.
Thank you.
Question. Could you state your address, please?
1717 South Monroe Street.
17.
Okay.
Do you understand that it wasn't the homeowner that made a mistake?
Correct. I think actually two mistakes were made. I will say that before I've ever embarked on a project, I've done as much homework as I could, including hiring an architect if I had to, before embarking on a project, or talking to a contractor who's done work in our neighborhood before embarking on a project. So I don't think that there's a fault on their side in terms of the approvals. That's unfortunately Arlington County, but I do think there's a due diligence process involved in any project you do. I don't care if it's buying a car, you're going to figure out what's involved in buying a car. I'm lucky enough I happen to be in this industry, so I understand all the questions to ask, but it doesn't matter. You still do your homework in everything you do, and I think today, information's a lot easier to access. So the information's out there if you ask the questions.
Thank you.
You're welcome.
Thank you. Questions, comments?
Madam Chair.
Mr. Smith.
When the government gives me a permit to do something, I can't second guess that. I'm not going to say, oh, that might be wrong. And I'm going to build, and that happens all the time. It's not uncommon for planning and zoning or permits, sorry, not planning and zoning, but permits, to make mistakes. And homeowners come to us just like this frequently. No onus on that individual whatsoever. It's not about his lack of homework or due diligence. Due diligence was getting the permits, and he had an architect. So now, with respect to the size of the dormers, that might be another issue.
I do have an opinion, but I'll wait. Mr. Melnick.
Okay, I had a question for staff. I would say, all the cases we generally have involving setbacks, there's a survey done, of surrounding properties, and maybe a little spreadsheet or whatnot. But in this, under the first question about compatibility development, it seems like the only things that are mentioned are that this garage is, except for the addition part, it's on the same footprint, and that the addition is the same length, or it's the same distance from the lot line as the previous, albeit it's bigger. But was there any analysis of surrounding properties in the neighborhood about garages being this close?
Yeah. No. I mean, I examined our maps and the plats we had and so forth. I don't normally draft staff reports for the Board of Zoning Appeals, so it's kind of not normally on my radar to think of that until Mr. Owen actually had emailed Sam asking for some information. So there is I did do some quick analysis of some of the neighboring properties that have.
Yes, I had an email exchange with staff asking a similar question. And so the board members have been presented with that information today.
Okay.
And I'm now concerned whether or not the applicant and the neighbors have any way of knowing what the content of that communication was, because I think they have a right to know as well what we were presented with. So if that hasn't been distributed, or if there's to date that hasn't been shared with the applicant, I think it might, Madam Chair, I think it might make sense. It's only about 10 sentences worth, but maybe it would make sense to have that read out by staff so they could hear what what's been presented to us.
Sure.
Yeah. this is what was shared with via email with the board members. The following neighboring properties in the vicinity of 1704 South Lincoln Street have detached accessory structures in their detached accessory structures in their rear yards in close proximity to the respective rear lot lines include 1713 South Lincoln Street. This is the only property on the cul-de-sac with 1704 South Lincoln Street that has a detached two-car rear garage. According to the historic house cards, the property was built in November 1960, the same year as 1704 South Lincoln Street, and the detached two-car garage was built in April 1965. The footprint of the detached garage is comparable in size to the applicant's proposed garage, approximately 590 square feet. 1701 South Monroe Street. This is a corner lot whose technical rear lot line runs along the same bearing as the applicant's rear lot line. The dwelling was built in 1941, and the detached garage was built by right in October 1950. The footprint is approximately the same size as the original garage on the applicant's property, i.e. roughly half the size of the proposed garage. The garage does not meet the current street setback standards from the 17th Street South right-of-way. However, the main dwelling does not either, probably owing to the fact that it was built prior to the adoption of setback regulations in 1950. 1735 South Monroe Street. This is a corner lot on the same side of the street, but at the far end of the block as 1701 South Monroe Street, mentioned previous. The property was originally addressed as 3541 18th Street South. This property has a rear detached two-car garage accessed from South Monroe Street, which was built sometime before 1963. Building permits were issued in September 1963 to replace the garage doors and again in October 1964 to repair the existing garage. The footprint is similar to the applicant's proposal. 3543 and 3539 18th Street South. These two properties immediately abut 1735 South Monroe Street. Both have detached rear garages in close proximity to the rear lot lines that are comparable in size to the applicant's proposed garage. There were no records in the historic house cards to indicate when these dwellings or their detached garages were built. The garage at 3543 18th Street South has a footprint of 576 square feet and is approximately 3.6 feet from the rear and left side lot lines, according to a survey plat dated 1999. Based on this footprint size, the garage should be located 10 feet from the rear and side lot lines. There is no record of a variance on file for this. The garage at 3539 18th Street South also has a footprint of 576 square feet and is also approximately 3.6 feet from the rear and right side property lines, instead of the 10 feet as required based on the footprint size. Again, there is no record of a variance on file for this garage.
All right, thanks. That's helpful.
Okay.
So the photos notwithstanding, which I think are dramatic to say the least, the issue is really only the setbacks.
Correct.
Right? And the building permit was rescinded because of that.
Yes.
Madam Chair.
Mr. Owen.
I first want to say that I absolutely believe that the homeowner in this case, or the applicant, was appropriately diligent and appears to have acted, in my view, reasonably at every step, given the level of expertise we expect homeowners to have. Unfortunately, no matter what decision we make tonight, someone's going to get hurt. I think that it's reasonable to expect that the property owner behind would lose value in their home from this construction. To me personally, there's no question about it. However, a denial results in an obvious financial loss to the applicant. So this is not a situation where we can ask people to talk and get a win-win. And it's just a hard decision that we have to make. In my opinion, this does not meet the criteria number 3 that we are required to find with the proposal, we have to find that, we have to analyze, would the proposal be detrimental to the public welfare or injurious to the property or improvements in the neighborhood? And I feel that it would, and on that basis, I cannot support the use permit.
I agree.
Madam Chair.
Mr. Malnick.
Yeah, I'm in agreement too. That I've looked at the pictures, and it was helpful to hear about other garages in the neighborhood, but the pictures are very dramatic, and they say a picture's worth 1,000 words, and I think this is true. It's just it looms. It does. I guess looms is the best way to put it. And I can see, how it could block out sunlight and whatnot. So I agree with Mr. Owen, that the question number 3 about the detrimental to public welfare, injurious to property or improvements, that it would be that. So I would vote against this application.
Other comments or questions? Or
These are just impossible cases because there's just no way on the planet that I think that a citizen should suffer a financial loss based on the government's decision. It just is wrong. I just don't see under what basis anybody thinks that that's right or fair. And so I can't, so, as Mr. Owen says, somebody loses. I look at the picture that the neighbor, Ms. Behrens, presented, and I do note that there used to be a garage there. That's not all new there. That there was a building there. It wasn't that building, but there was a building there. I don't know how I'm going to vote on this, but I just think it's so wrong that to hand a citizen a bill for a mistake that's not theirs.
May I say something in rebuttal to?
Just a moment, please.
Madam Chair, let me chime in and give my view, which is that the legal principle of estoppel we lawyers think about, and that's you really can't hold the government, even though they make a mistake. they get off. But, and it's totally unfair. My question really deals with if there isn't support to allow the status quo or for it to continue, to be completed, what might there be support for? Shorter structure? Removal of the dormers or some of the dormer. There's going to be some financial loss, some cost incurred in anything that's done to alter what's already been done. There's even cost to demolish what's been done. But I guess my concern would be, given the government's error, to minimize the harm on the homeowner. And to acknowledge that, yeah, there is some detriment to the rear, the neighbor to the rear, who then suffer this looming structure in their backyard, practically. So I guess that's where I'd want to hear the homeowner, and maybe one of the I think they're named
Barron.
Ms. Barron, whether there may be some consideration for the plight that the homeowner's in, and given some time and some reworking of the plan, with a plan for some reworking, whether that would be enough, A, to move my colleagues from where they are, and B, workable to the neighbor and the applicant.
Mr. Melnick.
Yeah, I think that's an excellent idea that Mr. Smith has, just to see, if there could be a deferral, the neighbors work with the applicant to see is there any middle ground, just to lessen having to, pretty much remove all the encroaching areas. But I wanted to clarify that I too, am very sorry to see when a permit's been issued and then rescinded. And, being an attorney myself, I understand, though, about the laws and the statutes. And, the laws were followed here, even though, this work was started under a permit that was later rescinded. But so I'm totally sympathetic about that, and I'm not trying to be harsh. But I look at the law, I look at the different criteria that we're supposed to look at, and that's what I'm going under here. I just try to follow the law, and so that's why I, have I stand by the comments that I made. But I do think that's an excellent recommendation to see, is there something less than removal of destruction in its entirety in working with the neighbors? So I could support that for sure.
Want to move it?
Ask the applicant. Madam Chair, the applicant had
Would
a
you-
comment. I wondered what his reaction to a deferral would be. If you'd like to step forward.
Would you come to the microphone, please?
Well, I guess at this point, anything to keep this alive would be preferable to the alternative. I did want to say, though, that when we were talking about cost and expense, the expense I have in this is real. Ms. Barron is talking about supposed expense, which may or may not be true. I'm not disputing that. I'm just saying I've spent real dollars on this that I can't get back, and if I can't finish it, I'm going to have to spend a lot more real dollars. And I live on a fixed income. I've been saving the money to build this garage ever since I bought the house. So just to try to gather the funds together to do anything differently at this point is going to be catastrophic for me. So, but to answer your original question, I would rather you defer it and give us a chance to work something out than just to vote it down.
Thank you.
Thank you.
Madam Chair.
Mr. Owen.
I just want to also be completely clear in saying that I agree with my colleagues who view the applicant situation as unfair to the applicant. Irrespective of how we wind up coming out, I have a great amount of sympathy for the applicant and don't think that, I don't really feel like he brought this on himself at all. And I think that he is perhaps understandably frustrated or even angry at being put in this situation.
Okay. Where are we?
Madam Chair.
Mr. Smith.
I'd move to defer V-11279-17-UP1 to the September meeting of the Board of Zoning Appeals to allow the applicant and possibly affected neighbors to discuss mitigation of their concerns.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for a 2-month deferral to the September BZA meeting. All those in favor?
Aye.
Thank you. Next case, please.
Case number V-11280-17-UP-1. Use permit request by Jeff Glockman, owner, to permit a setback of 7.5 feet to the deck instead of 21 feet as required from 10th Street North right-of-way for a new red deck to an existing non-conforming building in R5 zoning district premises known as 939 North Danville Street. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Thank you. Questions of staff? Applicant?
Yeah, I was just, I'm new to this, obviously, and thank you for seeing me and reviewing my case. And thanks for being here so late. If it weren't for Sam over here, I'd have no idea what I was doing with this, so he helped me out quite a bit. I recently took over my dad's fence company because he had a motorcycle accident, so I'm new to this. Like I said, we want to do a deck for the Gluckmans. They have an existing deck there currently, and as you can see in the picture that's there, that's the rear view of the deck that's there currently, and they'd like to remove that and just extend it 1 or 2 feet over to the edge of the building right there. As you can see to the right of that picture, there's trees all up and down the road, as well as a 6-foot high fence, so it's a corner lot. It's not visible from the road. And because it's so close, that's why we're applying for that use permit. We're not going beyond the corner of that building. We're actually going, there's a downspout there, so we're actually going about 4 inches inside of that downspout on the corner there. So yeah, I'm not sure exactly what I needed to do other than show up, and we did talk to the neighbors in the back as well as the side. I got the letters of intent for that signed by them, took pictures of everything, and yeah, that's about it.
Okay, good. Question?
Madam Chair?
Mr. Smith?
To wish your dad a speedy recovery. You did well. I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in B-11280-17-UP-1, subject to the conditions that are listed in the staff report.
Second.
Madam Chair?
Mr. Owen?
I note that we did not get any comments from the neighbors across 10th Street from this location. There's several townhouses that you can see in the photo here whose upper story back windows face directly to where the structure is going to be built, who would be ordinarily the most affected neighbors, although they are, it's a pretty wide street and they're far away, but nonetheless, they're the ones, I think, other than the neighbor on Barton Street, who would probably see it the most out of their actual home. So I'm a little bit disappointed that there was no outreach to those neighbors. I think staff even followed up with the applicant to ask about following up with those neighbors, and I don't know if you want to speak to your thoughts about the outreach.
I was
to those
not aware
neighbors.
that I needed to follow up with the neighbors 2 streets across.
It's
Is
just
there-
one street. So
Okay,
it's
well,
one wide street.
4 lanes. In addition, if you go back to the previous picture, there's like 20-some foot high trees right there. As you can see, there's no way they can see that deck from the road there. In addition, those trees are 6 foot high. There's a retaining wall with a 6-foot high fence, and those are above that so it's about a 30-foot to the top of those trees there that's covering the deck.
And that, thank you, and that gets me to the reason for my proposed amendment, which is to offer an amendment to require that tree screening remain in place as part of the condition for building this
Absolutely.
thing. And my understanding is the applicant does intend to maintain that same tree screening.
Absolutely, yeah.
So, without having heard from the neighbors, it's difficult. Maybe they would have signed off and said, we don't need any conditions, and this is all fine with us, and do whatever you want. But in the absence of being sure there was any outreach, I feel I need to be extra protective of what their interests might be. So
I hear a motion in there somewhere.
yeah, I moved that the motion be amended to add a new condition to say applicants will maintain, applicants agree to maintain tree screening between the proposed structure and 10th Street as depicted in the staff report.
Can we have the whole motion with the call letters and everything?
Sure. I ask unanimous consent to have as the main motion in item number V-11280-17-UP1 that the Board of Zoning Appeals adopt the resolution presented in the staff report with the additional condition applicants agree to maintain tree screening between the proposed structure and 10th Street as depicted in the staff report.
Could I have a second?
He asked for unanimous consent.
Oh, well, but we have to still, don't we have to second the motion?
I don't object. I think it's unnecessary, but the applicant has said that it's going to be maintained, so I don't feel a need to object.
That's the main motion, and then we can vote on the motion.
Can there, I need a clarification. So where is it referenced in the staff report? Can you just let me?
In this picture.
Okay.
In the picture currently before us, which I presume will go into the staff file.
Okay, thank you.
So we have a motion by unanimous consent.
We have an amendment added to the motion by unanimous consent.
To maintain the trees.
And so now we just vote on the motion that's now been agreed to as on the floor.
That Mr. Smith moved and Mr. Melnick seconded.
Got it. All those in favor?
Aye.
Thank you.
Good. Thank you very much.
Just don't take down the trees.
No, I'll make sure that they know that.
Next case, please.
Case number V-11281-17-UP-1 to permit a setback of 11.9 feet to the wall from the rear property line instead of 25 feet as required, and 10.7 feet to the eave from the rear property line instead of 21 feet as required for a new one-story rear addition in R6 zoning district, premises known as 227 North Wakefield Street. Staff recommends that the board adopt the attached resolution approving the subject use permit with condition.
Questions? Applicant?
Thank you for considering our application. We applied for a hardship application for this.
Thank you.
I told my husband to talk because he was taller. We applied for a hardship application regarding building on a small one-story addition to the back of our home so we could have a bathroom, a full-size bathroom, so we can do one-floor living as we stay in our house and as we start to age. Looking
Some
at
of us are
aging faster than others, yes. But looking at our lot, which is longer and shallower than most lots, that's why we're kind of encroaching there onto our setbacks. Looking at our neighborhood, the views, kind of looking at the foliage and everything around it, this is the spot for an addition that is the least intrusive and the least square footage that would be taken up. And again, we really want to have an area where we can live on one floor of our house as we continue to live with our family here in Arlington. Anything else, Ben?
You good? Okay.
It's even quite inspiring.
Questions?
I'd like to make a motion.
Mr. Melnick.
In case V-11281-17-UP1, I'd like to move that the Board of Zoning Appeals adopt or approve the attached resolution approving the use permit as applied for with the conditions as stated.
Second.
Moved by Mr. Melnick, seconded by Mr. Smith for approval. All
Aye.
those in favor?
Aye.
Thank you.
Thank you.
Next case.
Case number V-11282-17-UP-1. Use permit request by Veronica Seves Gonzalez and William Meher, owners, to permit a setback of 19.9 feet to the new front porch instead of 21 feet as required, and a setback of 18.4 feet to the porch eave instead of 19 feet as required from the front property line, and a setback of 24.6 feet to the second story addition from the front property line instead of 25 feet as required. For a new front porch, second story addition, rear two-story addition, and left side window well in R6 zoning district, premises known as 1918 North Woodstock Street.
Madam Chair. I have a question for staff. Oh, I'm sorry, I thought he was finished.
Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Mr. Owen.
On the picture in front of us, is the
My
red...
house, by the way, my house is the one next to it's the third house from Gleave, it's not the second one. So that's the
The
wrong
correct
house.
house is the one with the red and white vehicle in the driveway, is that right?
Yeah, the one with the red and the white, yep.
So one house to the right of what's depicted in the red box.
Thank you.
Thanks.
Applicant?
So I've been in Arlington for a while, and we have been in this house since 2010. We have 3 kids, and we overgrow it. And we just want to have an addition in the top and just a small porch in the front so that we can stay in Arlington and we can stay in the wonderful schools that we are right now. So, thank you.
Questions for the applicant?
I have a question for staff. The staff report says that staff recommends the approval of the use permit with the condition that the applicant move the shed 4 feet from the wall. I'm reading on page 3.
That's the next one.
I'm in the wrong place. Wrong house, wrong place.
It's okay, no worries.
It's late.
I
I
know.
dropped my packet.
Thanks for your time for being so.
I dropped my packet and I got it all out of order.
So,
Which one are we on?
I believe that the only signature we have is from 1922 North Woodstock Street.
Okay, I have them here. I'm sorry, I forgot to tell you guys.
You just hand the whole pile to Sam.
I have both houses on my side signatures and the one right across the street from us as well.
Behind or
I didn't
facing?
get to behind. I went 2 nights ago. I have 3 kids and I'm by myself, so I couldn't go. I went yesterday and it started pouring raining, so I couldn't make it there. I was with the three kids going around and start raining like crazy. But I mean, I could get them if necessary. We're very close to them.
The ones behind?
Yeah. Mm-hmm.
Okay.
Yeah, if we need the signatures, we can get them, no problem.
Madam Chair.
Mr. Owen.
So I think I'm going to vote in favor of this, but I feel like I'm just a tiny bit concerned. I just wanted to put into the record my concern that this is going to be, when I went out to look at it, it looked like on this side of the street, every single house that you could see from this vicinity was only 1 story tall. So, right, exactly. And so since our, our analysis is this similar? Is it compatible? I think this is a little bit of a borderline case. And to me, ultimately, given what's across the street, those are some taller houses, but this is kind of a dividing line. And so I'm glad to see some additional neighborhood signatures, because I do wonder whether or not after this gets built that there might be other neighbors on that street that says, here goes the neighborhood,
Well, somebody has to go first, and I think there are other neighborhoods in Arlington that started out like this, with all modest 1-story homes, and mercifully, most of them have been added on as opposed to whacked down and replaced.
Yeah, we're not going to replace. We love our 1952 house, so we want to maintain
Yeah,
that.
so I think that I appreciate your comment, but I do think that it's appropriate, and it's just the first.
Thank you.
Mr. Melnick.
If I could say, I understand the comments of Mr. Owen, but I would like to commend you on how it looks. I mean, it's an attractive house, the design, according to the drawings. So, while it's taller, it's true that somebody, if neighborhoods are going to go up a story, it looks like a very nice design. So
Thank you.
That's very good.
Thank you. We're the lowest house too, because our street goes down the hill. So we're actually the lowest house of all the houses. So that's something we wanted to maintain, so it doesn't look too out, because we don't like the massive houses. That's why we're building this house, because we don't want a massive house.
Let's go. Mr. Smith.
I too agree with Mr. Melnick that it's a beautiful design, and I agree with you, Madam Chair, that someone's got to be number 1.
Thank you.
And going straight up is better than going out. So, therefore, I move that the Board of Zoning Appeals adopt the attached resolution granting the use permit in B-11282-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Moved by Mr. Smith, seconded by Ms. Malice. All those in favor? Aye. Thank you.
Thank you so much. Thank you.
Welcome. Next case. Oops. Oh, yeah.
Case number V-11283-17-UP-2. Use permit request by Kathleen McCauley, the owner, to permit a setback of 6.5 feet to the wall instead of 25 feet as required, and 5 feet to the eave instead of 21 feet as required from North Burton Street right of way, and a setback of 1 foot from the wall of the second-story addition to the wall of a detached non-conforming shed instead of 8 feet as required, and 0 foot from the eave of the second-story addition to the shed instead of 4 feet as required, and 4.2 feet to the eave of the second-story addition, and 0.7 feet to the eave of the shed from left side property line instead of 5 feet as required, for a new 2-story right side addition, a second-story addition over existing enclosed right side porch, and a second-story addition over existing non-conforming single-family dwelling in R6 zoning district, premises known as 2505 Key Boulevard. Staff recommend that the board adopt the attached resolution approving the subject use permit with a setback of 6.5 feet to the wall instead of 25 feet as required, and 5 feet to the eave instead of 21 foot as required from North Burton Street right of way, a setback of 4 feet from the wall of the second-story addition to the wall of the detached non-conforming shed instead of 8 feet as required, and 4.2 feet to the eave of the second-story addition, and 0.7 feet to the eave of the shed from the left side property line instead of 5 feet as required, with conditions. Alternative resolutions are provided.
Questions? So am I reading that basically we'd have one area of disagreement, setback of 1 foot, and you're recommending a setback of 4 feet amongst all of those that you read? Is that the only disagreement?
This from the shed to, yes.
Might want to move the shed. Questions for staff? Applicant?
Members of the board, I want to thank you for reviewing this tonight. I also want to thank the staff for recommending our family's request. In October of 2008, the variance request that's before you was approved by this body. You all may remember that 2008 was the year that the economy crashed, and so we were unable to build the plan at that time. We're now able to build this home. We have been supported by our neighbors. We were supported by them in 2008. We're supported by them in 2017. Many of them are, in fact, waiting this evening to learn the results of your decision. I guess that's all I have to say.
So the previous approval for the shed was 4 feet, which is what the staff's recommending.
Mm-hmm.
And it is currently 1 foot, and you want to keep it there?
No, when Sam and I talked about it, I would love to keep it there so that I didn't have to go through what it takes to move it for 4 feet, but I'll move it 4 feet.
Okay, thanks.
So you're okay, you're okay with the staff?
Recommendation to move it, yes.
And you plan to move the shed?
That's what we have to do. Yes, absolutely.
Madam Chair, I have no problem if the applicant's happy and the staff is happy.
All right. Okay.
Madam Chair, I move that in case V-11283-17-UP-1, the Board of Zoning Appeals adopt the attached amended resolution. Oops, that just threw me. Attached resolution. The amended is the, let me see, which one is that?
Okay, which one do we want? If she's agreeing to the staff recommendation?
Is that the first one?
Yes, it should be the first one.
Okay, so it's just the
The approval.
just the resolution
Okay.
for approval. resolution for approval attached to our report, subject to the conditions listed in the resolution.
Second.
Moved by Ms. Malice, seconded by Mr. Owen. All those in favor? Aye.
I have to abstain. I was out of the room for a while.
Okay.
Sorry.
You're forgiven. Thank you. Thank you.
Thank you. And am I correct in understanding, Madam Chair, that today is your birthday?
Yeah.
I had heard a rumor. So,
how did you know
in
that?
addition to saying thank you, I wish you a happy birthday. And thank you for staying so
almost
late
over.
tonight. I understand.
Thank you.
Oh, how come we didn't know that?
Purposely,
We do now.
I guess.
July 19th.
Make a note.
Make a note.
Scary, huh? Next case, please.
I should have done that. I should have.
Case number V-11284-17-UP-1. Use permit request to permit a setback of 3.5 feet to an existing eave instead of 12 feet as required, 3.8 feet to a proposed column instead of 16 feet as required, and 7 feet to a proposed wall instead of 16 feet as required from left side property line, and an aggregate side yard of 14.4 feet instead of 24 feet as required for the structural alteration of an existing left side carport in R10 zoning district premises known as 4527 39th Street North. Staff recommends that the board adopt the attached resolution denying the setback of 3.8 feet to the proposed column and 3.5 feet to the eave, but granting a use permit for a setback of 7 feet to the wall and 5 feet to the eave of the addition with conditions. An alternative resolution has been provided.
Thank you. Questions for staff?
Madam Chair,
Mr. Owen.
am I correct in recalling that on this one, the next door neighbors were okay with the as advertised version? Is this one where staff has the main objection to the as advertised and is recommending the reduction?
I don't recall.
I can't remember who has which position.
Okay, let's hear from the applicant.
So, hi, thank you for everyone's time and happy birthday. We're Caroline Antonia Seve. We live at 2739th Street with 2 young children. We moved there May of 2016. And as noted in the application, our home was built 58 years ago. In 1959, it's a 1-story rambler with a walkout basement and an attached carport. At the time our house was built, the zoning regulations did allow carports to be constructed 3 feet from the lot line. And as shown from the application, our house sits over the current allowed setbacks on both sides. So our intent is to construct a mudroom for our family and to use the existing footprint of our house as it sits today. So as we embarked on this process, we hired an architect, drafted plans, and then in meeting with our neighbors to discuss the intentions, we learned that our neighbors directly adjacent to the carport were concerned about us wanting to build out the entire carport and finish that off as a mudroom. So we worked with these neighbors and our architect, came up with an alternative resolution that essentially would put the wall for the finished space 7 feet from the property line as opposed to the full carport. So they're in agreement as our other neighbors, and so we're hoping that the board will consider the proposed alternate resolution to approve as applied for this application. So happy to answer any questions.
Any questions for the applicants? No? Really? Okay. No questions. Got it.
Madam Chair, I would like to move the alternate resolution, which would grant the request by this applicant. So in case number V-11284-17-UP-1, I move the Board of Zoning Appeals adopt the attached.
The alternative?
Approved as advertised.
Alternative, okay.
Alternative version.
Good.
Second.
By Ms. Malice, seconded by Mr. Owen for the alternative resolution as advertised. All those in favor?
Madam Chair.
Oh, Mr. Owen?
I just wanted to make a comment that I think that this is one of those situations where the staff analysis, which sort of focused on the numbers and the plats and so forth, didn't tell the whole story. That there's topology and placement and characteristics of the neighboring properties that I think make this more compatible in reality than it seemed on paper. So I just, to me, that's the difference between the staff analysis and the approval that I'm going to vote for.
And Madam Chair, if I may, I just would like to express my appreciation for you actually talking to your neighbors before you got here, because that does make our job a lot easier.
Yes, thank you.
Thank you.
Okay, all those in favor?
Aye.
Aye, thank you.
Thanks.
Next case?
Case number V-11285-17-UP-1. Use permit request to permit a setback of 1.6 feet to the wall of an existing attached garage instead of 8 feet as required, and 1.2 feet to the eave/gutter instead of 5 feet as required, for an exterior or structural alteration to the roof of an existing non-conforming building in R10 zoning district on premises known as 4924 34th Road North. Staff recommends that the board adopt the attached resolution granting the subject use permit with conditions.
Questions? Applicant?
Good evening.
Thank you for your endurance.
Thank you for staying late as well. Yeah, so my wife and I purchased the house about 2 years ago. She's not here. We just had a son. He's 1 month old. House was built in 1959. There was an addition done in 96. The problem is that the existing kitchen is the original kitchen. So we're moving it to the addition. So and in doing so, we found out that we had to raise the roof on a false bulkhead, which you can see pictured there. So that's really the only thing that's changing. We've talked to all of our neighbors. They're all in agreement. It actually brought us closer together because we just moved there. So now, like, our neighbors brought us cookies the other day, so it's pretty cool.
That's what we're about.
What else? I think that's about it. I brought the builder with us if there's any technical questions. But I think, it'll increase the property value. It's not going to increase the footprint of the house. So I think that's all I have.
Madam Chair?
Mr. Owen?
To me, this is the easiest approval of the night. I move that the Board of Zoning Appeals adopt the attached resolution approving use permit V-11285-17-UP1, subject to the conditions listed in the resolution.
Second.
Moved by Mr. Owen, seconded by Ms. Malice. All those in favor?
Aye.
Aye. There's sometimes an advantage to being last. Thank you.
Very much. Have a great
Congratulations.
night, and happy birthday.
Thank you. Okay, that concludes the hearing. We have 2 sets of minutes. We have the May, and I had a question about the May minutes on page 8. This was the fence issue, and Mr. Owen had raised the issue with this, and the conditions are crossed out, but the resolution says approving a variance subject to the following. So it seems to me if there aren't going to be any conditions, that subject to the following should also be a strikeout. Minor point, but other than that, I didn't have any other suggestions for May minutes.
Madam Chair,
Ms. Malice?
My colleagues are ready. I move that the Board of Zoning Appeals adopt the May 17, 2017 minutes as amended.
Second.
Ms. Malice, seconded by Mr. Owen. All those in favor?
Aye.
Aye. Thank you. June minutes?
Madam Chair?
Mr. Owen?
In a couple of places, I see a few misspellings, notably my name. Also one other. So I can just pass those on to
Really
staff.
sensitive today or something?
My name is frequently misspelled, so I don't take it personally.
An S is added? Really? Oh, an S. Oh, okay.
So we can approve with correction of spelling?
Subject to spelling corrections.
Okay.
Peter Owen.
I'm singular.
No, Peter Owen.
Oh,
Not like Jesse.
not like Jesse. Okay, so,
The word website is misspelled, It's
okay,
not-
so
not
you,
big deal.
you move to approve?
I move to approve the minutes as presented, subject to some correction of spelling.
Second?
But don't go away, I got a question. I second.
Okay, all those in favor, of June minutes? Aye. Yippee. Okay, go ahead.
Madam Chair, I wrote you a quick note about the fact that we have an acting secretary. And I wonder if we have to appoint the acting secretary in order for them to be able to sign the minutes.
I have no idea. Is there an opinion?
I move to elect
Mr. Maba?
Mr. Imba, Secretary of the Board of Zoning Appeals.
Second.
Secretary or acting secretary?
Well, it's signed
He's
secretary.
already acting secretary.
Which,
Is that all right with
Acting as
you,
secretary,
zoning administrator?
I have no objection to that.
Okay,
Appoint him secretary. That's my motion.
okay.
okay, since he's signing secretary.
Moved by Mr. Smith, seconded by Ms. Malice, to appoint Mr. Mba as secretary to the Board of Zoning Appeals. All those in favor?
Aye.
Aye. Adjourn?
Opposed?
I didn't hear what I said.
No, I said adjourn.
I know you did.
We're done. We're done. Bye.
Well, but not as, but not as late as I thought. We thought July would be worse.
Okay. Yeah, I was wrong.
Well, if it weren't for the